That's the number.
Gotcha. Thank you. Hi. I'm Paul. Pleasure. Oh, who are you?
Go ahead and select organization, because you're the board president, right?
Yeah.
Select organization.
Okay.
And just say Mike Amato, board president, Colonial Village 3. Okay.
And the wording is, we have to check.
It's 7 o'clock. We'd like to get started, please.
Against.
Yeah, do we have to check this?
Okay.
I didn't
Now,
bring
go
it.
ahead and
I
put it
should.
up on that little- Yep.
Would you take a seat, please? Thank you. Good evening and welcome to the monthly meeting of the Arlington Board of Zoning Appeals, which is also known as the BZA. I'm Judy Freshman, Vice Chairman of the board. The board's made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Charles Smith, Ann Tomalis, Paul Melnick, and Peter Owen, who is our newest member, and this is his first meeting. This is trial by fire. Also present is a professional staff, including Deputy Zoning Administrator Andrew Knoxon, who serves as Secretary to the Board of Appeals. Harlova Vaughn, Acting Zoning Administrator, Clifton Hogan, Assistant to the Zoning Administrator, and Cheryl Williams, Zoning Technician. We thank you for being here and extending a warm welcome. To avoid disruptions, we ask that you please turn your cell phones or pagers off and put them in silent mode. On the front table, you'll find copies of the staff report for each case before us this evening. I recommend that if you've not yet seen the report for your case, that you get a copy and review it before your case is called. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the county board. This board does have the authority to do 3 things. We can approve use permits that allow modifications of placement requirements for structures on 1 and 2 family lots where there is no option in the zoning ordinance to allow such modifications. We can grant variances from the specific requirements of the zoning ordinance, and we can decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the board find that the proposal meet conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purpose of the master plans and land use and zoning related policies of the county. To do this, the BZA shall consider whether the modification will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint, size, and placement are similar to the structures on the properties surrounding the lot in question, and whether the modification will help preserve natural landform, historic features, and/or significant trees and foliage. When granting variances, the board must determine that the strict application of the ordinance would produce undue hardship, that the hardship is not generally shared by other properties in the same zoning district, and that the authorization of the variance will not be of substantial detriment to adjacent property, and that the character of the district will not be changed by the granting of the variance. When deciding appeals of the zoning administrator, the board must determine if the administrator acted correctly. This evening, cases will be called and a brief staff report and recommendation will be given. Following that, board members will ask any questions of staff they may have. Next, applicants or their representatives will be given an opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so their comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker slip, which is available on the table in the front of the room, and give it to Ms. Williams. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit and will not condone any cross-examination or direct questioning by others. We have deemed the following time limits for speakers to be sufficient. For appellants, 20 minutes. For representatives of organizations on appeals, 3 minutes. For individuals on appeals, 2 minutes. For use permits and variances, 5 minutes for applicants, 3 minutes for representatives of organizations, and 2 minutes for individuals. And I might add, this is a very tight schedule with 3 appeals, so we will be vigorously enforcing time limits. After the board has gathered all the information they need and discussed the case, it will decide the matter by voting in a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you're welcome to stay for the balance of the session or leave at your convenience. Again, thank you for being here this evening. Please call the first case.
Good evening. We would like to ask your preference. The first case, the first appeal, at the end, we were planning to play a video that was included in your packet, but we're having some technical difficulties. So we wanted to know if you wanted to take something out of order or proceed without the video.
What's your pleasure? What is the likelihood of the technical difficulty being solved?
We're going to try a few things. We have IT hopefully coming.
Okay.
Maybe I'll pull it up on this computer and play it through the speakers on that one.
Okay.
I don't know if we'll
So-
be able to do the video at the same time. We may be able to do it, but we might have to sync it up.
You recommend that we move on? Okay. While we work on our technical difficulties, we're going to go to the second item on the agenda.
So that would be case V-11121-16-APP-1, an appeal by the Ballston Park Homeowners Association, Incorporated, of an administrative change request approved by the zoning administrator regarding changes to loading dock hours in the CO 2.5 zoning district in Site Plan 401 on the premises known as 900 North Glebe Road. Okay. I'm just going to briefly go over the actions that have taken place, the appeal, and the determination and my position on it. As mentioned, this is a property in Site Plan 401 at 900 North Glebe Road. The figure shows the outline of the property, and the 2 stars represent the one at the upper right is the approximate location of the loading and parking facility, and the second one just represents the location of the townhouses that are adjacent to the office building. Just for a little background, Site Plan 401 was approved by the County Board in February 2008 for a multi-building, multi-use project with 2 office buildings and residential units. There are 2 site plan conditions number 39 and number 40, which provide for an administrative approval to modify the permitted hours to use the loading dock, recognizing that those needs might differ from the standard hours that are included in the site plan condition. This slide is meant to give a little more information about the location of all the various facilities. So you can see the 900 North Glebe building, the approximate location of the loading dock, and this is an older image at which time the townhouses hadn't been constructed. but a request was granted via an administrative change to approve an extension of the hours of uses of the loading facility for a conference center, the Virginia Tech Center, located on the second floor of the 900 North Glebe building. Conditions number 39 and 40 both actually address usage of loading facilities for trash recycling and deliveries. They both contain criteria for which an administrative change may be granted and refer to the tenant's demonstration of need based on their business and operation. Both conditions also grant the zoning administrator with the authority to extend those hours. And condition number 39, which is titled Interior Trash Collection and Recycling Areas, does require notice for the applicant to inform other building tenants of the site. The applicant's request included justification referring to their use of the loading dock for access to provide catering deliveries for special events and meetings that occur in the conference facility in hours that extend beyond the 9 to 4 p.m. and 6 to 8 p.m. on weekdays and 9 to 6 p.m. on weekends for early morning meetings and late night events. In the text of the appeal, there was mention of the fact that this would be in conflict with the Arlington County noise ordinance, and I just want to be clear that the administrative change granted cannot supersede compliance with other Arlington County codes and ordinances. So therefore, I feel that the request was properly granted, given the standards provided in the site plan conditions approved with the original site plan. The remaining images, just to give you some context of the location of the loading facilities, and just moves you around the site. This is where the townhouses are located, and that shows the entrance to the drive that accesses the loading facility. That concludes my comments.
Any questions for staff?
Madam Chair, I have a number of questions about this case, some of which will be directed to staff, but I wonder if you want to go through them all now or after all the other parties have spoken. I have technical questions that...
Well, I am assuming that the speakers would not address those. Is that correct?
Right, I'm just talking about the order, if the speakers would like to speak.
Go ahead.
I just want to clarify, when we talk about the site, we're talking about the buildings that include the townhouses.
So the site of 900 North Glebe, the property does not include the townhouses.
Does the site plan include the
The site plan does,
So
yes.
the site plan includes the
Yes.
townhouses. So when we talk about there being a notification of tenants of the buildings, does that includes the townhouses?
I believe it could, although given that this is an office building, I would think that refers to tenants of the office building, because that's where the loading facility is located.
I guess that may be a point of disagreement, because it seems like if the site plan is talking about all the buildings, then we're talking about the tenants of all the buildings.
I guess I would have assumed that would refer to property owners, because they're individual townhouses.
And that are tenanted?
It's,
I
yeah.
have people shaking their heads back and forth. That's why.
Go ahead.
Madam Chair, so I'm getting into some of the sort of discussion of this before we have speakers, and I wondered about the appropriateness of that.
Well, in my view, I think the clarifying details of the site plan and related issues should be out there ahead of the speakers.
So we agree that the townhouses are part of the site plan.
Yes.
And therefore, when it refers to the site, it's referring to the townhouses as well.
Yes, the townhouses are included in the site, but
When it says tenants of the buildings on the site, I assume that means the townhouse people.
Well, if I could, the tenants the townhouses are individually owned. They're not leased. So a reasonable interpretation would be,
Would you introduce yourself?
I'm so sorry, I'm Christine Sanders. I'm the Assistant County Attorney with Arlington County, and I'm assisting the zoning administrator in this appeal. I realize that condition states that notification to tenants on the building, and we did have a lot of discussion about that, but the townhouses are not leased, they are actually owned. And the other point I would just, of clarification about that specific language, I think a close reading of it, it's fair to say that it is the tenant requesting the change has to justify it to the zoning administrator and give notification to other tenants.
Right.
It doesn't say the timing of that. It doesn't say, and the tenants it's not clear.
So I'm cautious about getting into the argument at this point, but I would argue that point. I don't know when.
Okay, go ahead with your other questions.
Move on to a different point, or just continue arguing this one?
No, go ahead.
So, as someone who is familiar with site plans and the process that is used, to come up with these, I would say that this was put in here, and this is speculation. I was on the Planning Commission when this was adopted. I don't particularly remember negotiating this condition because I think it happened after the Planning Commission was. But these kinds of things are put in sort of for the protection of all the people on the site. And so that's the way when I read this, that's my sort of non-legal way of reading this, that this is not just the Virginia Tech building, but it's everybody on the site. And since we have residential so close to the office building and the loading dock, those buildings that are that are occupied by residences are particularly impacted by what happens in the loading dock, and so would have a great interest in understanding what the request was, what the justification was, because the way this was written assumes that we had a settled thing, and everybody was happy with this settled thing. Now we have a movement to unsettle it. It seems like all the same parties ought to be part of the new discussion, and so that's sort of what I'm trying to think through. But that's the way, when a plain reading for me indicates that this is everybody in the site, and whether they're tenants or owners, they're on the site, and therefore have a keen interest in being notified that the hours of the loading dock are being changed because they're impacted as residents there. So I've given you my whole argument before I've heard all the other sides.
Other questions?
I might. I guess I would have a question about the zoning administrator's thinking in deciding what the new hours should be. We went from something that was very conservative, that was again negotiated as part of the site plan by neighbors, commissioners, all the multiple people that are involved in a site plan. And it was rather conservative. I think it was conservative for a reason, because of the close proximity to residential tenants, residential occupants. And so the thinking of how did we go from something that's fairly conservative to something that's very broad is something that's of interest to me. And I don't know what point you want to take that up, or if you want to discuss that now.
Madam Chair?
Go ahead.
And I guess just to, I have a interest in that second part of her question with respect to the deviation from what it looks like the staff, M. Pfeiffer, recommended. I'm wondering why the deviation from those recommendations to what we see before us.
So that's two questions.
Sure. The consideration was that this is a conference facility, and the types of events that they have are meetings and then evening special events. And so it seemed reasonable to expect a conference, a meeting or special event, to happen before 9, which would require, because there's no, it's not a meeting hall where there's a commercial kitchen or facilities, large facilities for storage. So it seemed conceivable that there would be a need for deliveries to occur early, for early morning meetings, and to allow unloading at the end of a night event. With regard to the planning recommendation, I'm not sure why Matt bifurcated it in that way. I was responding to the request, and so the hours of the request were what I was granting.
On that point then, the Virginia Tech building was known to be a conference center from the moment it was conceived. That use did not change. It was, when the site plan came through, it was understood that this building was a conference center. So the argument that a conference center needs different hours was, I think, already discussed as part of the site plan process. That you know, I don't know what changed, because if this was appropriate when it was a conference center, when it came through the site plan process.
I think that's why the condition was written that way, because the standard condition doesn't allow this flexibility. So the county board in its approval anticipated the need for this flexibility by granting administrative approval to change the hours.
That's not exactly how site plan, I'm sorry to be debating both of these points, but that's not exactly how site plan works. I mean, site plan actually decides what the hours are going to be. Here there was a, but if it becomes if there's a tenant, we already knew that the tenant was there. Again, I'm slightly recalling, slightly speculating, but positing that this condition was really meant for if a commercial tenant came in and said, if we're going to open up a cafe or a coffee shop, obviously that will need to be serviced. But the use of a conference center was known from the moment this project was introduced. I mean, that's what it was. So I'm having a little trouble.
Okay, let me suggest that we hear from the appellant because some of the issues that are of concern to the board have already been raised.
Madam Chairman, if I may, I agree with your proposed way of proceeding because I do think that will be helpful. But if you don't mind, I would like to just announce some of my questions in the hopes that maybe some of the other speakers will also address them.
Certainly.
And I note also that Mr. Smith's question was still pending. I don't think there was an answer to that.
Essentially, I heard from the zoning administrator that there wasn't really any reason for a deviation that she could articulate.
It was what the applicant requested.
Yeah. So some of my questions are along sort of a similar line. I served on the Transportation Commission for many years right before this plan came through. I think I ended my service right around the time that this came through, so I might not have been serving on the Transportation Commission when this happened. But we discussed loading dock conditions a lot there too. One thing I noticed was that it appears that this condition was partially amended after the Planning Commission discussion, but the staff report of record does not mention the reason for the change. I would be interested to know if anyone has information about whether anything was discussed at the board, whether anything was discussed during the Planning Commission meeting that's in the record that might help explain why this condition was changed in between the Planning Commission and the board, because for me that would help inform the legislative intent of the changes. The loading dock hour conditions have evolved a lot over the last 15 years. And so figuring out what the baseline is against which this is changing is, to my mind, a little bit of a moving target as well. But I did compare this condition to the similar condition in site plan number 409, which was approved on October 4th, 2007, which is on 1712 Wilson Boulevard. And that condition also has, in the board report, added language some of which is similar to this, which talks about if a tenant demonstrates the need to accommodate morning patrons and so forth. And so it does not appear to me, based on that the changes to this condition were all specific to this site. And so if any of the staff or the speakers later want to address how much of this was intended to address this site specifically versus being a sort of an evolving standard condition change, that would be, I think, helpful to me to understand the legislative intent. And again, as a further illustration, it does appear that this site, that the change to this site, if I'm reading it correctly, excludes 4 p.m. to 6 p.m. as an allowable time to use the loading dock. And I couldn't find any indication of why that exclusion, which is unusual, why that was added. And I would be interested to know what about the applicant, I guess I'll say how are we naming the tech center? The applicant, the applicant, let's just say the applicant, but that's who I mean. What about their application to require things for a conference center overrides the need to not have deliveries between 4 and 6 p.m. as opposed to just, in the morning hours or the late night hours? Is there anything, because one thing I could imagine, although I couldn't find any record to support it, is that perhaps there was a traffic interest, right, to not have, during the rush hour, to have traffic backing up. And so that's potentially interesting to me as well. And then finally, just to back up way, way up, and maybe I should have put this out earlier, to me, the underlying purpose of loading dock hour restrictions, what is staff's view, what is anybody else's view of why there should ever be any restriction? Why shouldn't all loading docks be 24 hours to begin with? Whose interests are meant to be protected by restrictions on loading dock hours, and does that help inform any of the other questions that are presented in this site plan? So those are some of the questions that I had.
Okay.
Yeah, I also just wanted to throw out my thoughts, for consideration. And what I'm wondering about is, in the determination of this administrative change, what, if any, consideration was given, to noise levels and how they might affect, for instance, the neighboring townhomes? Or was this just simply an internal, a decision only, only considering the needs of this particular office building and conference center? So that's, if that could be addressed, I'd appreciate it.
Okay. Let's move on to the applicant. You have 20 minutes, please. When the bell sounds, sit down. And state your name for the record, please.
Yes, good evening. My name is David Kartner, and I'm here under two capacities. One is being that I'm a resident impacted from this situation, and another thing is I'm a representative of the board of Boston Green. And so I'm here. My other two compatriots cannot be here, but we have the support of other two that have spearheaded this appeal, and I'm going to defer to a lot of them for what they're talking about. But just want to say a few couple of words, minutes here, and then I will let them speak. Okay? So as I said, I am a resident and is impacted from this. I am the corner townhouse over there, right behind this unit of Virginia Tech. That being said, I'm going to let them talk about all the pictures and all the impacts that they see and that we have built as a group, as a whole. But I just wanted to inform the board and just to kind of reconsider the Virginia law. I'm a lawyer here, a real estate attorney, and the law around this area, especially you could almost consider it as a nuisance to us, has been upheld by the Virginia courts quite a few times regarding that. Basically, in National Energy Corp. versus Quinn, the court stated that when a business enterprise, even though lawful, becomes obnoxious to the occupants of neighboring dwellings and renders enjoyment of the structures uncomfortable by virtue of the example of noise, dust, or offensive odors, the operation of such business is a private nuisance to us. Not that we've really gotten into that point of where we're thinking about it, but we want to understand and want to make it clear to the board that this is something that is a big deal for us, and if we set this into a motion that we're worried about the neighboring communities, I know we have quite a few different communities here that would like to talk at the end, but the courts of Virginia have set up this area, stated that this is a big thing that they view that, your quiet and use enjoyment of your property is very important to them and also everybody else. And I know there has to be a balance struck between commercial and residential, and especially when we're in such close proximity of each other. But I'm asking, and the board's also asking that, it's just something to consider when these things are approved and so forth. I'm going to turn it over to John, who has spearheaded the appeal, and he'll talk more into detail about what's going on.
Like to hand out some items.
Identify yourself, please.
Oh, I'm sorry. I'm John Fedewa. I am one of the residents of the.
Thank you.
I'm not actually on the board, but I'm helping on this project.
Multiple sets.
Yeah, take one, pass the rest out.
We already gave you some photos in the original appeal application, but unfortunately they were a little cryptically labeled, and rather than just resubmitting them with more labels, we decided to give something a little bit more current. Most of those 40 photos are from this current month. In fact, the very last image is from 6:30 a.m. when a trash truck woke up every single person in that back 9 of townhouses. So it does have a real impact on us on a daily basis. We don't believe that the procedures are in place, not only now, and you can see under each photo there is it says day and then a 4-digit number. That corresponds to, I believe, June 29, 2011, when the ribbon was cut on Virginia Tech's property. So we think there's been ample time to get these procedures and systems in place. And I know Mike and some of the other residents will speak for themselves, but my wife and I moved to this location because of its proximity to everything. We pay a premium for these conveniences, and we know that the various planning commissions and such in the county spend a lot of time on these issues. So we were very shocked that our quiet time could be reduced by 50% without us even knowing about it. And it was only really circumstances that allowed us to know in time to make this appeal. We're all new to this process, so if we ever have to do it again, we'll give you much better exhibits. So quickly, just going through, reacting to some of the comments I heard to my right from the county, there seemed to be some notion that the townhouses were not part of the conditions, even though I personally, and I think my colleagues, believe that conditions 39 and 40 are flawed, the result perhaps of some editing process that didn't quite conclude. It is clear that under 39, the last section indeed covers the townhouses. So I think that anyone to say that the conditions don't cover the townhouses, in fact, the beginning of condition 39 even also mentions the townhouses. So as was pointed out, I can't imagine what the loading dock restrictions are there for, if not for the neighborhood and the townhouses. Our position also in condition 39, which, by the way, that is the condition, if you look at the paperwork, that is the condition that Virginia Tech cited in their request for this 50% reduction of quiet hours. And that is also the condition that appears to have been cited by the zoning department. So I think that is potentially relevant. I'm not sure. But in any case, 39 and 40 have a lot of redundancy. And if at the very least there seems to be some confusion as to what applies and what does not. In particular, we find some objection to the word demonstrates and need. We don't feel that these documents that were provided as justification for the application for the extension of the loading dock hours By the way, they were already doing this anyway for 1,700 plus days, so this was just a way to paper up what was already being done, I think. Anyway, we don't feel that those documents, unless there was something more substantive, which we did not have access to, we don't believe they demonstrated, in the common sense definition of the word, an actual need. We also, from camera footage, we can see that vans are primarily the catering company vehicle of choice. We, on a daily basis, see vans go into the parking garage without any problem, doesn't disrupt anybody in the townhouses. They can do it 24/7, I think, as far as I'm concerned, and probably my colleagues would agree. So a lot of this seems to be a pointless exercise. Also, just as a bit of irony, the loading dock itself, if you've ever walked into a loading dock, it's quite high. It's several feet higher than the bed of a van. And once again, the reason that the catering vans in so many of these images appear to be unloading outside the loading bay, which is a violation of the conditions, is because they can't push their van directly up to the loading dock itself and empty. They have to take it down and around. So the whole thing, I'm not sure why it was ever the best, why there was a need, why it was optimal, et cetera, et cetera. Furthermore, in Condition 39, it says that these hours may be changed. It doesn't say they must be changed. So one would believe, or one would come to conclude that if they may be, then they may not be, and if they may not be, there must be some reason why they may not be. So if that's the case, then it would seem that even if the tenant does demonstrate under some scenario a need, which everybody here would agree to in some hypothetical situation, even then the zoning administrator doesn't need to make the approval. So we just thought we'd point that out as well. Additionally, was it last summer, Mike and Dave, that the Green Turtle sought noise hour expansion, I think their patio or something like that. In that case, we were treated like members of the site plan, and we were notified, and there was a public hearing, and there was all sorts of outreach sought and given, and I think everybody said basically the Green Turtle was fine. So we don't understand why there's such a why there's two standards, I guess, essentially. So, let me just quickly go over, since I do have a little bit more time. Also, in the way of background, before the HOA officially got involved, there was some dialogue between residents, myself included, and the property management company. I take the position, and I think the board takes the position, that that predates the official action, so we have not included any of that correspondence. But should it become relevant, or should it become quoted, we do have copies of that if it is ever needed. We didn't feel like it was necessary, but so finally, before I turn it over to Mike, in the document it says that over 24 site plans were examined. I have the numbers of those. There's a lot of people in this room who actually would know what those mean. Site plan 430, 72, 46, 386, 418, 426, 2, 64, 429, 331, 193, 432, 435, 297, 437, 438, on and on and on. In none of these, except for 193, could we find hours that were earlier than 8 a.m. or later than 6 p.m. Certainly not going to say that there are none that exist in this county. There's so many different site plans, but those are the ones that were nearest us. And in Site Plan 193, which happens to be Ballston Quarter, which is relatively new, you can see, and we've cited it in our revised supplement, you can see more evolutionary language, which probably is the result of situations like this, where everyone looks at the text and nobody can quite remember how it got to be that way, and so it's much more deliberately written. And certainly one theory is that a lot of what went into that probably was intended here, but I wasn't part of the Site Plan 401 process, so I can't personally tell you. Lastly, we've seen that the Code of Virginia that authorizes the appeals format, and it seems to, again, coming down to semantics, it says it relies a lot on the word correct, whether or not the administrative officer was correct. And then, of course, it says the board shall consider the intent of applicable ordinances and laws, et cetera. Others will speak to the intent because they were party to it. I wasn't. I have a common sense reading of what it means. But in the term correct, we don't believe that that simply means authorized. It, I think, would impart some meaning of just and wise and considerate and equitable. There's probably a lot of other terms which it could mean, but I'll just throw that out there for food for thought. So at this point, I'd like to introduce Mike O'Connor, and he can add a little bit more to this.
My name is Michael O'Connor. I am an owner and resident. So thanks for taking the time. It's going to be a little bit more focused on quality of life and impact because that's why we're here. Quick background, I've lived in the area for nearly 10 years. Love the community, its conveniences. In fact, I bought a townhouse here because I enjoy living here and its conveniences. But as I think to the future, being still relatively young, I'm looking to have a family and build a family, have children. I can't do that here. And especially with this change and with the noise from the loading docks, it's going to be impossible. As John mentioned, just this morning, and I'm feeling a little tired and there's a reason for that, 6:30 a.m. I was awakened by a loud bang. At that time, I was shocked awake, and then I heard another bang, and then another bang, and then some dragging and some diesel engine idling, and then some more banging. And the last photo in the handout is actually from 6:30 this morning when a large dumpster was being dragged away from the building. This is obviously within the quiet hours of the county and well before the 7 a.m. time that you would expect some kind of noise to happen. At that point, I was unable to get back to sleep, looked outside, thinking maybe there were some perishable goods being delivered to the building, but unfortunately, I saw a big bin of drywall and other construction materials, things that should probably be appropriately addressed during the workday when everybody's awake and at work. And if that indeed was perishable goods, then I think that there are larger problems than the timing of the delivery. So at the end of the day, what it comes down to is we are trying to live as a community. We're trying to interact with these businesses. It's a quality of life improvement to have these nearby businesses that offer these conveniences. But these noises and delivery trucks constantly coming and going and not unloading while the loading dock is closed like they're supposed to, blocking the fire lanes. One day I was coming home from work and I was trying to pull into my driveway and I was unable to because there was a large truck that would not fit in the bay. And being unable to get in, I had to get out, inform the driver to move the truck. They moved the truck, and I was able to go park. But those types of things shouldn't be happening, and that's why the hours are designed the way that they originally were. So John gave a very, very clear overview of the points and the facts that we have identified, and hopefully my side gives you a little bit better of a view of the impact it's having on us as people and residents. Anything else you want to close up with? Thank you very much for your time.
Thank you very much. Can we proceed with the speakers? Okay. Steve McKnight.
Pardon
Pardon me, Madam Chairman, we forgot to hand this out. This was a gentleman who was supposed to be here, but couldn't make it because he had childcare concerns.
Okay, thank you.
Not quite wearing tonight.
Madam Chairman, members of the board, thanks for the opportunity to speak on behalf of Virginia Tech. I'm Steve McKnight. I am the Vice President for Virginia Tech's National Capital Region, and I am here with several members of my team that represent and manage the Executive Briefing Center on the second floor, which is the entity that submitted the request. We're all located in that building, and we also have here Cliff Hamner from Tallheimer. He's the property manager for the building, and Cliff serves all the building's tenants. In addition to us, those include the other offices in the building as well as the restaurants. He also oversees all the building-wide functions such as parking, security, waste, recycling, and other building-wide functions. My purpose here today is to represent the Executive Briefing Center, which is a core function of our enterprise in Arlington. Before I get into that a little bit, I want to say that we are very proud to be a member of the Arlington community. We decided to locate our research facility here over 8 years ago, well before my time with the university, but about the time I started working in Boston at the National Science Foundation. We did that because we felt it was important for the university to have a strong and prominent presence within the Arlington's vibrant and innovative science and technology environment, and we wanted to do so in a very open and public square perspective. Since opening our doors in Boston in 2012, we have grown our research activities to hopefully exceed more than $25 million this year. We've established partnerships with many Arlington-based companies, the county itself, as well as many community groups. At the same time, we have continuously built relationships with the county, stakeholders, and our neighbors. We place a great value on these relationships and strive to ensure our presence has an overall positive impact on Boston and the county as a whole. As such, we have utilized our Executive Briefing Center to regularly host county meetings. We convene scientific meetings among science and technology experts to help work on community issues. Things like resilience, emergency response, and the integration of technology to improve Arlington's ability to be resilient in the event of a man-made or natural disaster. We've also sponsored numerous publicly open scientific and technological lectures, many of which are all conducted on the Executive Briefing Center. In short, supporting this community is very important to Virginia Tech, and we take all the constructive feedback from our neighbors very seriously, and that's why we're here tonight. With regard to the matter at hand, we believe we have acted in good faith when using channels available in the provision to aggressive administrative change that would allow our Executive Briefing Center to receive deliverables of perishable goods to support meetings and conferences. We do not have any requests associated with trash.
Mr. McKnight, please sum up.
Thank you. Thank you.
Yes, Mr. Owen.
Just as they were finishing, he was mentioning trash service, which is actually a question that I had, and I wondered, is now the appropriate time to ask, or should I wait?
Go ahead.
I was wondering if the speaker who was just here if you might address what are your goals with regard to trash service during the expanded hours?
Our request does not pertain to trash. Our request only pertains to delivery of perishable goods for our Executive Briefing Center. The trash, I'm just as appalled with the reconstruction of the Green Tunnel guys. I got blocked in by a truck myself too. So we are really just trying to do the things that we need to do to conduct the business that we have on the Executive Briefing Center. I know in 3940 they both mentioned trash and perishable goods. I'm not a lawyer, I'm not a planner, I'm a professor and a university administrator. We're trying to conduct our business. This is about being able to get deliverables in so that we can conduct the business on the second floor. Thank you.
Madam Chair, before the speaker leaves, sir, I want to clarify what you're saying. You said you were appalled by something?
The construction that is ongoing now to remodel the current restaurant, which was the Green Turtle, I think it's an Applebee's now, is ongoing. And so there's quite a bit of hustle and bustle, and the construction workers who do not work for me are also perhaps not the most kind when they are trying to unload things, which has nothing to do with the matter at hand, or has nothing to do, I know it has everything to do with this community, but it has nothing to do with the matter at hand and trying to be able to deliver.
But what about, and what about trash collection to the building?
That trash collection has nothing to do with the matter at hand. We are only requesting the ability to deliver perishable goods associated with the catering, because we have no storage facilities and we have no kitchen on site.
Okay, so you're not speaking for the building owner?
I am not speaking for the building owner. I'm speaking for Executive Briefing Center, which is part of our core business in that building on the matter of Virginia Tech.
Thank you.
Just in the interest of moving along, I would just say that it sounds to me like we're raising, part of this issue is raising issues that aren't pertaining to this application per se, but maybe have more to do with building management, and zoning can look into violations.
Madam Chairman, I'm sorry. I agree with that in the interest of moving on, but I also think that it also relates to the substance, insofar as whether or not the zoning administrator, the scope of the zoning administrator's ruling was narrow or broad.
May I be excused, or are there any questions? I'm happy to answer.
Thank
we
you.
also have the building manager here.
I've got one question. You made the application for the expanded use?
Executive Briefing Center made the application, yes.
Well, that's an inanimate object. I'm looking for a person.
Virginia Tech made the request.
Person?
No.
Did it?
No.
Oh, okay. Do you know who did? Who actually instituted, drew up the piece of paper and sent in the letter?
Nick? Where is she?
I'm just wondering if they were aware of notification issues, notice to other tenants.
I'll defer that question to Cliff.
Maybe if they're a speaker, maybe when it gets to them.
Good evening. My name is Cliff Hamner. I'm the property manager for the building at 900 North Glebe. In conjunction with the foundation, Kerry Woodring, myself, and the foundation submitted the application on behalf of the Virginia Tech tenant for the second floor. And then to your question, again,
the notice to other tenants.
You'll have to excuse me as a property manager for 20 plus years. When I read, and I'm not a lawyer, I'm a property manager, if it says notify the tenants in the building, it's pretty straightforward to me. It's simply a matter of notifying the tenants in the building, which was done in conference and email to all the tenants in the building in that case. And there was no attempt to deceive. As soon as we had any kind of recording or from the zoning administrator, we notified the major complainant immediately of what the situation was.
I'm sorry,
Sir, did you fill out a speaker slip?
I did not, ma'am.
Would you please do that?
Yes, ma'am.
Thank you.
And that's very helpful to me. Thank you, Madam Chairman.
Any other questions?
Not at the moment, but stay tuned. Next speaker, George Rovder. I apologize if I mispronounced your name.
Thank you, Madam Chair. That's a very good pronunciation, Rovder or Rovder.
Attention, please.
Thank you, Madam Chair, and members of the Board of Zoning Appeals and members of staff who are here this evening. My name is George Rovder, and I'm the president of the Bluemont Civic Association. The Bluemont Civic Association was a party to the site plan negotiations, and we are on record since 2008 welcoming Virginia Tech Foundation as a neighbor in our civic association. We welcomed Virginia Tech in a letter to its Chief Operating Officer, Mr. Raymond Smoot, at the time, and the county board was copied on that letter. At our February meeting this year, the Bluemont Civic Association members voted to support our neighbors and our members who are residents, some are owners, some are tenants, at the Ballston Parks Homeowners Association in their appeal of the change of loading dock hours. We discussed it, and the members overwhelmingly supported our neighbors' rights to quiet enjoyment of their property and maintenance of their investment in the property. I speak this evening, the Bluemont Civic Association members also authorized me to address our support to the members of the Board of Zoning Appeals, which I did in a letter, which is a matter of record. I speak this evening to reemphasize that support that the Bluemont Civic Association has for the appellant, in this case, the complainant. And I would like at this time to extend my appreciation as a fellow citizen to each of you on the Board of Zoning Appeals who give your time and your talent. And I know these volunteer jobs are very onerous, and we really appreciate you being here as fellow citizens to able to modulate the official and the legal and staff views and recommendations as fellow citizens. And we count on you to use your judgment to come to a right and just solution to this problem. And that solution is probably not either or of the draft resolutions that were provided by staff. So again, thank you for the opportunity to speak this evening, and we strongly support the Ballston Park Homeowners Association.
Thank you. Next speaker, Khalid Usman. I know that's two.
Hi. Thank you, Madam Chairman, for giving me the opportunity to speak. My name is Khalid Osman. I'm one of the owners and residents in one of the townhouses, which is actually right in front of the loading dock. And I'll just make a quick few points. I think one point was we are definitely not notified about the impending change, and there's a lot of noise which is outside the quiet hours, which I think is not fair to us as residents. Secondly, it does affect the quality of life severely. As some of my neighbors mentioned, actually, there were a lot of loading happening outside the quiet hours. We have some neighbors which have kids. I have my parents who come sometimes from overseas. They need some rest as well. I do travel a lot for work as well, and as you can imagine, once you're jet lagged and if there's something right outside your bedroom window at like 5 in the morning, that severely impacts your productivity for probably the next couple of days. So I think just on those grounds, I think it severely impacts our quiet hours. And also, I think just as an act of fairness, we do abide by all the noise regulations. So I do think it's a little bit unfair that we are abiding by all the noise regulations and then our quiet hours are being disturbed by some kind of ordinance which would be unfair in that position. Thank you very much.
Thank you. Next speaker, Surdit Sen.
Good evening, Madam Chair and the board members. My name is Surajit Sen. I am a resident like my neighbors here, and Khalid just behind the loading dock. I'm the middle unit. I have a family, a young family, wife and 2 kids, 3 years old and 5-year-old, and we're really impacted by the noise in early morning hours. The biggest impact was this morning, as you've heard time and again. We were all sleeping. We were abruptly woken up by loud banging, loud noises. Children came running in. Sometimes in the evening hours, there's a lot of noise and they're distracted. I think it affects our quality of life and our peaceful living there. So that's really what I wanted to talk about in terms of a family. We are affected by that. Thank you.
Thank you. And the last speaker, Suzanne Sundberg.
I'm Suzanne Smith-Sundberg, a 20-year Bluemont resident. I actively participated in the SPRC process for 900 North Glebe Road and site plan number 401. Our community welcomed and encouraged Virginia Tech to locate its research center in Bluemont. We supported Virginia Tech's request for rezoning and changing the GLUP to achieve the substantial increase in building height and density that Virginia Tech requested. The county, for its part, has supported IDA bonds benefiting Virginia Tech, and the Virginia Tech building is exempt from local property taxes. Moreover, my brother is a Virginia Tech graduate, so I too am supportive of Virginia Tech's mission. However, Arlington residents, whether they are renters or owners living in multi-family or single family, should have the right to a decent night's sleep in their own homes. The fact that the county's noise control ordinance restricts disruptive noise-generating activities during defined nighttime hours, including weekends and holidays, reflects the county's intent to protect residents' right to peace and quiet during the overnight hours. Throughout the site plan process, Virginia Tech was well aware that housing units would be built in very close proximity to its building. It also agreed to the loading dock operating hours specified in the site plan conditions. The purpose of including an administrative option to modify loading dock hours was, as I understand it, to provide some flexibility for future ground floor retail tenants. The bakery example provided in the site plan conditions supports that interpretation. The intent of this flexibility was not to provide Virginia Tech with a means of avoiding its responsibility to properly control its loading dock and to prevent the use during prohibited hours. Virginia Tech's Conference Center has been in operation since 2011. There is no new tenant or circumstance to justify such an extreme change in loading dock hours. I therefore respectfully ask the BZA to find in favor of the appellant. Thank you.
Thank you very much. Okay. Discussion, questions?
One more question. So does the effect of your ruling is that the loading dock can be used from 5 in the morning till 11 p.m. for any use?
For the conference facility, for the delivery of perishable goods.
So
that's who asked for it, and that's who it's granted for.
So does it include trash collection?
That wasn't part of that wasn't part of what they were requesting.
So they're requesting only catering trucks to be allowed during this period of time.
I don't know if we would limit to the type of vehicle, but it's whatever is needed to support that business needs. So it might be catering in the morning. It might be taking out furniture. You know, if there's a need to bring in equipment, but it's whatever supports the use of the conference facility. Particularly, it was the part of their request referenced the fact that they have events that are catered, that are early morning events.
I'm sorry, I'm still not totally clear on this point. So are you saying that at this moment today, it would not be consistent with the revised site plan condition for an ordinary trash truck to arrive at 8:30 in the morning?
That's correct.
That would be a violation. That would be a site plan violation. Okay, thank you.
Other questions?
Madam Chair.
Yes.
And this is directed at staff. I'm looking at the application for an administrative change, and it's, I don't know, about 10 pages in, and the statement of support, and it's, they say, we request that deliveries in support of the conference center operations be permitted. And that seems to be the only, it doesn't deal with unloading and with removal of anything, but just deliveries too. So it's just in support of the conference center's operations, not in support of anybody else's operation, and it's not in support of the removal of trash or construction. If the conference center wanted to do construction, like the Green Turtle, and they would have to come back for another administrative change for the purpose of permitting the access of construction equipment using the loading dock during. With the original hours for that, are the original hours in place for anything that's not requested within this application?
There usually is. I don't have it at my fingertips. There's usually actually a totally separate condition that addresses construction hours and activity, and I can find it if you want. But that's generally regulated separately, and often, unless it was written in and I could look for it, we've often had cases where applicants have to go back to the county board to modify those hours.
And Green Turtle construction would not be, they wouldn't be permitted to use the loading docks outside the times that were established in
Shouldn't be.
2000. Shouldn't be.
Right.
And
Nor should trash.
nor any of the trash collection. Which
No.
would come, the Virginia Tech Foundation owns the whole development,
Right.
I presume. So they are to blame, members of the community, for not the research center per se, which only wanted deliveries for the purpose of their facilitating their conferences. Right? Isn't that correct?
Yes.
Madam Chair?
Yes.
So how would this new condition be enforced?
Well, with most of our conditions, we often don't hear about them until they're violated. So we get complaints in, and then we contact the property owner, inform them, and try to work with them to get to compliance.
Now, just to be clear, the property owner is Virginia Tech Foundation, is that, that's right? So the conference center is part of the Virginia Tech operation. It's not a...
There's a separate
entity.
But it's part of the Virginia Tech family. Yes. I mean, it's got Virginia Tech in its
The
name.
Virginia Tech representative should probably...
I'm not sure why the quibble.
Well, it's not a quibble. If they're the owner, I would bet that the research center pays rent to the foundation and has a lease agreement. They're a separate legal entity, and the building owner is the responsible party. One of the tenants, as the conditions 39 and 40 say, asked for permission to operate outside of the loading dock hours. One of the tenants, not all of the tenants, not Virginia Tech Foundation. They asked on behalf of one tenant. So I make that quibble because I think it's an important distinction, and I think for the benefit of the neighbors, they shouldn't expect other folk to be coming in making deliveries outside of the original times, other than the Virginia Tech Research Center. I think it's an executive conference, executive something or another center, when they're having conferences and need to have deliveries for the support of those conferences, not just general activity, but their conference center.
Madam Chair, just to finish my thought. So in terms of enforcement, it would be incumbent upon the neighbors to complain if they see non-catering trucks.
Yes.
But they've been seeing all these other instances of trash and collection and stuff. Have their complaints changed the situation?
I have been, when this came up, I met with the zoning inspector for this area and asked if there were active complaints, and was told that there were none.
That there were no complaints?
Exactly. That were formally logged with us.
That will change.
Okay, let me see if
Other questions?
Madam Chair? Yes. So this, I mentioned this before, but for an administrative change, one of the things to be considered is the intent of the site plan. And I notice, but there's the time is one thing in the original site plan, but also that loading dock doors are to be closed while it's in use. So obviously, quiet, keeping noise levels down was very important. So what if any consideration was given to noise levels when this was changed, from 9 a.m. to as early as 5? Was that a part of the mix of the thought process of the administrative change?
I guess the condition of the site plan require that the noise ordinance be complied with regardless. So what if there are different, if they're quiet hours as being spoken of that provide for different amounts of sound, they would still have to be met. This doesn't give anyone the authority to exceed those.
Question?
I'm ready to try and move things forward a little bit.
Spectacular.
So my view is that this administrative change was not reasonable. I think that the history of these site plan conditions in the era that this plan was written suggests that this particular condition was meant in the first place. Condition number 39 is applicable. I think that's the most reasonable interpretation. I think that within condition 39 as amended by the county board during the site plan process, the notification to the tenants of the building on the site has only one reasonable interpretation in light of the purpose of loading dock hours, which is to notify the people who are meant to be protected by the loading dock hours. And so the appropriate, I do agree with the zoning administrator, however, that I don't see a requirement that it be the zoning administrator who do the notification. And so I do think that before granting the administrative change, in my opinion, it was incumbent upon the zoning administrator to satisfy herself that someone had notified, even if it wasn't the zoning administrator herself. I was surprised and comforted to learn during the meeting that, in fact, the administrative change is limited strictly to the vehicles that were requested and that there is no broader scope. And I think that's consistent with the county board's practice. For example, when grocery stores have moved into buildings and the county board in a site plan amendment has adjusted loading dock hours, they've generally limited the expanded loading dock hours only to the purpose of the grocery store. And so I agree with the zoning administrator in that limitation. The two tougher questions in my mind are, one, was this amendment even meant to cover an office tenant? And when I look at the history on the other site plan I mentioned, number 409, that was a building that didn't have any office tenants. It only had retail tenants. And so I think there is a reasonable, if the zoning administrator had decided, look, this isn't a retail tenant application, and so it's just not what this was meant to apply to, I would have found that reasonable. However, the question is, what about the reverse? Is that also reasonable? And I think I'm required to presume that the zoning administrator is correct unless the preponderance of the evidence shows to the contrary. And I do think that this set of conditions is vague enough that either interpretation is reasonable with this poorly written condition. And then finally, the question is, were the actual hours approved reasonable? And there I'm inclined to say no, but I might, through further discussion or hearing from my colleagues with their greater experience and wisdom, I might settle one way or the other on that. So I just, to get it out there where one person is, thank you.
I was actually looking for a motion, but I guess we're not ready for that.
Well, I'll be happy.
Well, Inta?
No, you first. You have seniority. Please go ahead.
I would like to move the alternative resolution. And do I have to read the whole thing? Okay. Whereas the Board of Zoning Appeals has held a duly advertised public hearing on April 13, 2016 on the case V 1111-11121-16-APP-1, an appeal of the zoning administrator's administrative approval to extend the hours of the loading dock pursuant to condition 39 and or 40 of the site plan 401. Whereas the Board of Zoning Appeals finds that the zoning administrator acted beyond the scope of authority granted to her pursuant to the Arlington County Zoning Ordinance 15.5.3 4.c and condition 40 of the site plan 401. And whereas the BZA finds that the zoning administrator's approval of Virginia Tech's administrative change request for use of the loading dock was invalid and incorrect. Now therefore be it resolved that the BZA hereby reverses the zoning administrator's approval of Virginia Tech's administrative change request for the use of the loading dock pursuant to Arlington County Zoning Ordinance Section 15.5.3.c and condition 40 of the site plan number 401.
Is there a second?
I'll second.
Discussion?
Madam Chair, the Virginia Code empowers us to hear and decide appeals of determinations by the zoning administrator. And really the only question is, was the zoning administrator correct? So it's really a yes or no. And in my view, the zoning administrator was asked, pursuant to the site plan conditions, for an administrative change in the hours for the loading dock use by the research center. And the only thing the condition required was for the applicant to demonstrate a need for this additional time, which I think by way of their explanation they did. And it's limited to that. So I believe that the zoning administrator, narrow authority to either say yes or no to this request, and then to determine hours. And there really isn't anything that talks about the zoning administrator's authority to do anything other than grant a request. And I think they did that in this case. So I don't have a problem with what they did, and I certainly understand the neighbor's concern but on the other hand, when you buy a residential unit that looks out onto 16-foot tall doors that say loading dock, you've got to expect that loading is going to happen and that trash trucks are going to make noise. I know outside of my condo window, I hear the first bus in the morning at, I don't know, 5 something, and throughout the morning. And of course, trash that comes to our condo unit picks up early in the morning, and I hear all the containers. But that's kind of what I understand to go along with urban living. And certainly in the Ballston corridor, where there's mixed-use development, you're going to have a lot of different, you're going to have nighttime noises from the entertainment district, you're going to have daytime noises from the normal office use, and then you're going to have morning noises from the kind of constant construction that now goes on along the corridor and the deliveries that have to be made. So I can't see myself associating with the motion that's made in the second. I'm going to have to vote against the motion.
Any other comments?
I would like to speak to my motion just very, very briefly. I think it is regrettable because I think everybody in this room and in Arlington welcomes Virginia Tech, and so there's absolutely no question about that. But I do think that, as my colleague just said, the close proximity of urban living requires more communication, not less communication. And I feel that because my reading of this is that the neighbors should have been notified, the townhouses should have been notified, that they missed an opportunity to participate in the decision that affects them a great deal. My reading of that site plan condition suggests that that opportunity was put out there for that purpose, that they would have an opportunity. Whether they prevail or not, they can seek other remedies, but they would have an opportunity.
Anyone else dare to comment? Or care to comment? Thank you. Just for the record, I concur with my colleague to my right. Let's call for a vote. All those in favor?
Aye.
All those opposed? Nay.
Nay.
The motion passes 3-2. Thank you. Are we ready for the first item, or do we proceed from here? We're ready? Okay. We will now go back to the first item on the agenda.
First item is case V-11120-16-APP-1, an appeal by Robert Jones of a violation notice stating that the building on the subject property is an unpermitted multifamily dwelling in the C2 zoning district on the premises known as 5029 23rd Street South.
Thank you.
Madam Chairman, I'd like to object to whatever film is going to be shown. I'm not sure what the county wants to show, but I think they got to show the whole film in the entirety or none of it. So I'm going to object to whatever the county wishes to show.
So noted.
We've already seen it.
You've already seen it?
It was in our. It was part of the
our packet.
It was part of our packet. So
Okay.
it's hard for us to unsee it.
Well,
We could see the whole thing, but we didn't. We didn't.
But you saw a part of it.
We just saw.
Well, my objection is that the county kept trying to put words into Mr. Jones's mouth. Mr. Jones is here. He can speak for himself. But they were trying to demonstrate that the bottom had been used commercially, and he kept saying there was some equipment left there that he removed. And so I don't know what you all saw, but I certainly object to it.
I don't. Speaking for myself, I don't know if there was more that we didn't see, but we did see a portion.
It was about a 2-hour hearing.
No, it wasn't. We didn't hear a 2-hour hearing.
Okay, can we have a ruling on where we are to show this or not to show this?
Well, Madam Chair, I agree with Ms. Malice. The bell has been rung. It can't be unrung. We were given as a packet, and I presume that the appellant was not given that.
Oh,
Well,
dear.
but I guess I would, the bell can't be unrung. We've got it.
We have it
And
signed.
it's, I think for the purpose of the record, well, I think that.
I think the applicant has it entitled to
I
see
think
it.
they have an absolute right to see it, number one. Two, I don't think we can not now not show it. I think we have to, given that we've seen it. We are a duly constituted public body. But I'm going to say that, Mr. Lawson, I don't think that it changes really anything in terms of I don't think it changes anything in terms of my how I'm going to view actually, I think it's kind of, I don't see how you can get around anyway the facts that are kind of contained in the, what was it, 2 minutes or 3 minutes or so? It was a relatively small snippet. I hope that we're able to see it. But that's what I would encourage, Madam Chair.
May I address the appellant's question? I'm Min Chao Korn I'm the Assistant County Attorney representing the Zoning Administrator today. I would just, the Zoning Administrator. I'd just like to say that the clip that you were shown and that we plan to present today was a clip of a hearing before a public body like yourself, and both the appellant and Mr. Lawson were present. So nothing that's going to be said during that clip is going to be a surprise to them. And, if they would like to play more of the video or more clips of the video for you to give you more context, we have no objections to that. But the entire hearing is 2 hours long, so it's just not feasible to.
Is Mr. Lawson prepared to do that?
I mean, he has an absolute right to see it, number one. And he actually, Madam Chair, I would have thought staff would have said, we're going to, introduce this, just FYI, and email the clip to him,
Should we defer it?
when they knew about it.
I'd like a deferral for a month if I could. So
Well,
I
if
can
the only
view it.
issue is whether the video can be, we're fully prepared to proceed without presenting the video.
Well, but we've already seen it.
Yep.
It seems to me that we should defer it.
Yes, I agree.
so that the applicant and the appellant can see what we saw, and that we're all singing from the same page. Okay? Can we have a motion, please?
If I can find the paperwork.
Well, we just defer this. Here, just defer this.
Madam Chair, I move that the Board of Zoning Appeals in agenda item V-1120-16-APP-1 defer this appeal of the zoning administrator's determination to the May 11 meeting of the Board of Zoning Appeals.
Second.
Is there, Madam Chairman, the appellant requested the appeal, and it wasn't clear to me whether or not the county consented to, the deferral. Does the county also consent to the deferral?
Yeah, I mean, I defer to the zoning administrator, actually.
Sure. Okay.
Okay.
We have a vote, please. All those in favor of deferral?
Aye.
Aye.
Aye. See you in May. Next item.
Next case is V-111-22-16-APP-1, an appeal by Roslyn Heights LLC to a violation notice stating that the use of the property as a dog run is not a permitted use in the RA 716 zoning district, part of site plan number 161 on the premises known as 1804 North Quinn Street.
Questions of staff?
On the dog run, okay. Changing gears quickly here. I have just a couple technical questions. Is a dog run or dog park defined in the zoning ordinance?
No, I actually had a few comments, but we can, if you want to,
I'm sorry?
if you want to move forward, we can move forward.
Go
But-
ahead.
Okay.
Go ahead, please.
Just briefly, the subject property is part of Site Plan 161-7, approved by the board in March 1985. It was approved for a residential building, and the approved landscape plan for the site plan showed the area in question as a landscaped area, open and unenclosed with trees and plantings. Zoning enforcement staff first were alerted to complaints regarding noise and visited the property in August 2015, observed a fence that had been constructed without a permit, and that the enclosure was used to allow dogs to run freely for exercise. The applicant applied for a fence permit, but ultimately it was rescinded because it was determined that it authorized something that was not consistent with the site plan approval. The owner's agent was instructed to remove the fence and return the area to the condition shown on the approved landscape plan. After some deliberation, it was determined that an administrative change was not an appropriate option because approving so would not be consistent with the spirit of the original approval. And over the course of a few months, portions of the fence material were removed. Ultimately, a violation notice was sent on December 31st, instructing what needed to be done to achieve full compliance, which would be remove all the portions of the fence and replant, and to do so by March, because that occurred in December. Generally speaking, modifications to site plans are allowed administratively if they are consistent with the intent of the original approval and other criteria. A dog run was not considered as part or approved as part of the original site plan, nor are they authorized as permitted uses in the subject zoning district. The county code does permit dogs to run off leash in areas under the ownership of their owners and in areas specifically designated for exercise. In Arlington, those are public parks, 8 of which have accessory dog parks within them. Therefore, it's the zoning administrator's position that the fence permit creating the dog run enclosure was rescinded properly and the notice of violation was issued properly. Oh, sorry, that's it.
Thank you. Questions for staff?
All right, now, dog run and dog park, are they defined in the zoning ordinance?
They are not.
Okay, and does the leash law prohibit owners of their property to, if I had a dog, would I be able to put my dog in the backyard?
Yes.
Okay. So what's the difference here?
This is a apartment building, so the property is not under the owner of the property is not the owner of the dog, right?
And
Not the whole owner.
Yes.
Site plan violations.
15th or 100th owner.
Exactly.
And my other question has to do with the landscape plan, which we're relying on. If I put a picnic table somewhere on the site, would that be a violation of the landscape plan?
Good question.
I think it's hard to make a definitive statement. Probably not. It depends on, I guess, the activity that it generates, whether or not it's bolted to the ground, if it's a permanent structure. We kind of have to look at each type of activity or each thing that's introduced on a case-by-case basis.
So your ruling is not relying on the site plan, the landscape plan, it's relying on the leash law?
No, it's relying on what's shown there, but you can request administrative changes to put up things like fences or other structures. But in this case, the fence created an enclosure that permitted a use that was not anticipated there.
But
it happens fairly commonly to request a construction of a fence via an administrative change for a site plan. Okay.
I'm trying to just get in my mind what that landscape plan restricts. And when I ask about a picnic table, you're not so sure. But if it's a dog exercise area, let's say without a fence, just, somebody drew a circle and said, this is where, if you walk your dog, you can walk it here. Is that different than putting up a picnic table?
I think the activity that's associated with a dog run has a very different impact than if someone wanted to put extra seating there for people. If a picnic table is a little different because that, again, could lead to other things. But I guess there's benches there now, and I don't think adding a bench there is a problem. But when you change the nature of how that area was used, which seemed to be intended for passive landscaping, that was where the distinction was made.
Madam Chair. Is what you're referring to is a similar use interpretation, about, these things that aren't specifically in here, and you look at, what is it like that is mentioned? Okay.
Yeah.
Thanks.
Yes.
Thank you, Madam Chairman. I am still a little stuck on the relevance of the leash law. So my colleagues posited the example of if you're a homeowner and you let your dog in the backyard, that's your property, so it's okay to let your dog go off. What if you lease a house, a single-family home in Arlington? You're not the landholder, you're a leaseholder. Are you not allowed to let your dog in the backyard of the house that you're leasing?
I'll let Christine answer.
Christine Sanders, with the county attorney's office, one of the assistant county attorneys. I take your point, and I understand, I think, what you're trying to get at, but I did just kind of want to sort of facilitate this discussion a little bit and sort of assist the zoning administrator. I think that the only reason the leash law was brought up is because it was part of the applicant's justification, and we feel it's a red herring. The leash law is part of the county code. It doesn't speak to use of property. It's essentially a code provision that requires, if you look at the intent and spirit of all of it, to how people are allowed to keep dogs and when they're allowed to have them on leash and off leash and where they can. It's for the public safety in general. And I think that the applicant threw it into their appeal as a red herring, and it really can't create a use on property. It is not part of the zoning ordinance. And that's what the zoning administrator facilitates and interprets, is the zoning ordinance. So I just wanted to sort of kind of put that out there, and that it was her, I think, effort to try to let you all know that the leash law really has no application in this instance.
So, oh, sorry.
She can't interpret the county code. That's not part of, that's beyond the scope of her authority.
I find that to be a very helpful response. And then I would follow up by noting that in the zoning ordinance, section 12.2.3A3, residential use categories, household living, accessory uses include specifically listed the raising of pets and recreation as permissible accessory uses in a residential zone. And I'm wondering if you feel that this activity is different than the accessory uses described in that section. And if so, why?
And I'm just trying to understand your question. So I think what the zoning administrator's position is with respect to what happened in this instance on this property is that the landscape plan had a function, and it was to create a buffer.
I'm sorry. I'm sorry to interrupt you, but because it's such a long meeting, I want to be sensitive to the chairman's interest in moving things along. That's not responsive to the question I'm asking. So I'm not, the zoning administrator's decision here was based on several grounds, one of which was whether or not the landscape plan was vindicated. And I feel I well understand the landscape plan element, but the zoning administrator also appears to have grounded her decision in the fact that this is not a permitted use under the zoning.
Correct.
So that there's no by right, this assertion the zoning administrator made that there's no by right ability to do this, essentially. And also made an argument that under the site plan, this use was restricted. And I guess I'm not sure whether or not that's only because of the landscape plan or for other reasons, but let's leave that aside. The zoning administrator appears to be asserting in part that even if there was no site plan, that a dog run in this zoning category is not permitted.
That's correct.
And so I'm wondering how is that reconciled with the explicit permission to raise pets and recreate in a residential zone?
I think they're mutually exclusive. I think you can raise a pet and have a pet, but to create a place where you change the character and function of a piece of land that's designed and approved by the board to be one thing into something completely different is where the violation exists. And that's, she cannot, the zoning administrator can only find, the county board approved the site plan. She cannot, without express authority, change what the county board approved, nor can she change the zoning text. Okay, that also requires county board approval. I think she's within the scope of her authority to have looked at this and said, is the function and character of this strip of land that's by virtue of adding a fence, dog receptacles, water bowls, benches, and so forth, has that changed this into a use that's not been permitted or approved on the property, either under the site plan or allowable under the zoning ordinance? I think that that was, on her behalf, an appropriate finding.
Thank you.
Thank you. Could we move to the applicant, please? Hello? Is there an applicant? Roslyn Heights, LLC?
Oh my gosh. Do you have a motion?
So there's no applicant. Okay.
Can we proceed without an applicant?
Well,
Hello?
really, Madam Chair,
We just hear
the
this.
applicant really is the county zoning administrator saying, I made a determination, and the building, you know, the folk who put up the fence, they don't really have to be here.
But who's appealing?
The neighbors.
The actual property owner was.
Well, they have to be here.
They're not here.
They're not
That's
here.
a problem.
They're not
Is there a
here?
motion?
Well,
Okay, then.
could they have been seen, not that I think that they did, but could they have been seen to have met their burden of production with their written submission? Do they literally have to
Says
appear?
right here, applicant.
We can't question them
All right.
if that's part of our role.
Might stand on the merits of what we have. Does it just, Madam Chair, may I ask a question?
Can make a motion. I just, was staff expecting?
They noticed. They knew that they should be here. They're not here.
And you have no information about why they're not here?
They're represented by Walsh Colucci. I mean, they should know the rules.
Okay. What's your pleasure? What's your recommendation, Ms. County Attorney?
I'd say that the Board of Zoning Appeals is free to make a motion.
To defer?
That's one of the three things we can do. We can hear it and decide yes, no, or defer.
We have a lot of speakers. My guess is that they all are opposed to this.
And they may not want to come back in another month.
Madam Chair?
Yeah, let's get them on the record.
Madam Chair, is it possible for us to hear the testimony and carry this over until the applicant appears, or we get clarification? No, to the next hearing, because I'm a little troubled that we don't have an applicant, but we could hear the testimony.
We've done that.
And
Well, in that case, we hear the testimony, so you don't have to come back. But we don't act on the appeal.
Clarification.
Is that correct?
What sort of-
Attorney?
We could.
Unfortunately, I can't give you all legal advice.
No,
I
but
represent the zoning administrator.
We have to decide.
Well-
We can, Madam Chair, we can do exactly that. And
Okay.
we've done that in the past. We've taken the testimony and we have then deferred the matter and carried it over and reflected in the record that we've taken the testimony prior from the number of witnesses. They're all they get listed in the minutes, and then act on the zoning administrator's decision.
I would also be interested in taking Chris up on on Drew's suggestion that he see if they have an explanation for why they're not here
before the meeting
during this meeting.
Well, we can do both.
Yeah.
Yes. I don't think it's reasonable to expect people to just sit here and wait to see if somebody shows up at the end of the meeting.
No.
So
I'm not suggesting that.
I'm comfortable with listening to what you all have to say and deferring it unless that's legally impermissible.
Madam Chair?
Yes, sir.
I'm in agreement that we ought to move it to effectively the end of the docket, if you will. But the thing about hearing testimony, I'd prefer, just since the appellant was noticed, that I think it's going to lose some of its impact if we take testimony tonight and then defer it for a whole month. Then we're going to run into a whole nother hearing. And I don't know if that's a good use of time. So I'd be more inclined to give until the end of the hearing and then make a decision then. But if they were noticed, I think that, I don't know what that shows, but if they're noticed and they know they should be here, it doesn't show much of an interest in this.
Madam Chair, I actually agree with Paul 100%. I would take the testimony, and we don't have to defer it. We can act on it. I feel even more comfortable doing that, given that they were noticed. You say they're represented by Walsh Colucci.
Okay.
They certainly know the rules, so.
I get it.
And then they have the right to appeal if they don't like what happens in circuit court. Maybe that's what they want.
Let's move on.
Madam Chair, can we do both? Is there any reason that?
Okay, here's my suggestion.
Make a call?
Yeah, we got to move on. So I think we're going to take all the testimony, and then if there's a sentiment for moving forward, we will. If we have to defer it, we will. I'd rather get it gone. I think when you're represented by Wells Colucci and you don't show up, there is a message there. So let's move on, shall we? First speaker, Mike Amato, Colonial Village Association. 3, please. Is there debate about who's coming? Oh. Yeah.
For the association, and I think the association would prefer that I speak.
Would you
first.
speak into the microphone and identify yourself, please?
Yes, Zachary Williams, I'm the attorney for the association. I've also filled out a speaker's slip. I think the association would prefer if I speak initially.
Did you fill out a speaker slip?
I did.
Okay, I don't have one for you.
Mike, what is it? Amato?
Mike Amato.
You're Mike Amato. Okay, so you want to speak on behalf of the association?
That's correct.
Okay, you need to fill out a speaker slip. But you can do it retroactively.
I did fill one out, Madam Chairman.
Him, that's him. Sitting next to him. Go. Start.
Hand it to her?
Yes.
Then it's gotten mixed up.
Repeat your name.
Zach Williams.
Oh, I got you. Okay, thank you. Go.
Madam Chairman, members of the board, Zach Williams, land use attorney from Bean, Kinney, and Corman. I'm representing the Colonial Village 3 Association. It's an historic residential community. It's located adjacent and to the west of the proposed dog run in this case. I would first say I think it would be entirely appropriate for the board to decide in favor of the zoning administrator in light of the fact the applicant is not here.
Of course.
Thinking that would happen, but that's the first thing I would like to put on the record. Secondly, we do have several residents who are going to be speaking tonight to the specific impacts of the dog run. And Mike Amato here is a board president as well. And I just want to say in short, we agree with the county's position, agree with the zoning administrator, ask that the board affirm the zoning administrator's determination. In short, site plan 161.7 controls development here and the land use on the Roslyn Heights property. Again, this is a rental property. Just want to make sure that's clear. The site plan doesn't permit a dog run, and on that point alone, to change a use requires board approval. Zoning administrator does not have authority to do that. Secondly, in this exact location where the dog run is proposed, there is landscaped area approved, and the purpose of that is to stand in as a buffer, a very important buffer between Colonial Village and the parking lot. Nor is a private dog run or dog park permitted under the zoning ordinance, and we've heard some discussion about that. It's not permitted in any district in Arlington. We have some county parks, but we have no private dog runs permitted or existing anywhere in the county. What's to the appellant, I was going to say, is incorrect in arguing that dog runs are similar in intensity to other uses in this district. That was in their paperwork. I assume they would have argued that tonight. As this case illustrates, the dog parks and dog runs are very active, noisy uses with unique impacts, very different from other uses that are permitted in this district. And as you've seen from the written comments, they create very unique and significant impacts on adjacent residential properties. For that reason, we respectfully request that the board find the zoning administrator's determination to be correct. Thank you.
Thank you. Mr. Amato.
Thank you. I'm a little loud. My name is Mike Amato, President, Colonial Village 3 Board. I'm here both as a resident and also as a representative of the community. The purpose, like our entire society is based on law, and that's where everything builds from. And in this situation, Roslyn Heights is trying to circumvent the law to their advantage, and I think they're clearly aware of that. Some of the pictures that came by show it, but basically the dog run that they set up where this vegetative buffer was is along a fence close to Colonial Village buildings. And when the dog run was operating, there were dogs running, a lot of dogs, a lot of individuals barking, growling, about this distance. So you can imagine you're taking care of your children, you're trying to sleep, you're eating, and right here is extremely loud noise. And I think that if you look at even just the evidence on its face, Roslyn Heights is aware that this is a nuisance. There's a reason why this dog run is not next to their buildings. It's as far as humanly possible from their own residence. And I don't say humanly possible as dramatic flair. If you look at the property, it's so far away from their own buildings that one of our Colonial Village fences actually served as a buffer for the four sides of their dog run. So literally, if you travel an inch over that line, you're in Colonial Village. So it couldn't be any further from their own. And this is a big deal for the residents. If you ever search to buy a home, it's an extensive process. You're trying to find this. I'm a little biased, but I think Colonial Village is a crown jewel. It's a historic district, and we have green spaces. It's quiet. It's the environment's very welcoming, but also natural. The change from vegetation to a situation where you have a lot of noise at all hours, and I believe that we submitted video showing early AM up to midnight, barking, growling, talking, and just to the point of a dog run versus a single individual on a leash. If you have one dog and you're holding it on a leash, it acts a lot differently than if you have multiple dogs and they're all running wild, which is how that situation was. And in addition, the urine and the feces, to point out, and kind of disgusting, that's along that strip, that's a smell that's going to make you, if we're this close, you're not going to want to open your windows. And you can imagine how much worse that's going to get once the temperature and the humidity spike in the summer. So on behalf of the board and the community at large, I would argue against the dog run.
Thank you very much. Paul Maurer.
I appreciate you all considering this. My wife bought our unit, and one of the major reasons she bought it was because of the proximity to the metro, but also the quietness. There was no sign saying, loading dock or anything like that. It was a buffer there. It was trees, and that's the way it was supposed to be, and that's what she bought. I understand if the zoning was different, but that's what the zoning mandated. So it would have a major impact on us because our windows are from this distance to you, from the proposed dog run. That means we hear the German Shepherds, the Dalmatians, the Labs, not only barking loudly, but growling and playing. And collectively, it's a lot different than just somebody walking the dogs. Dogs behave very differently, and that's why you all regulate dog parks differently. So I hope that you will not succumb to Roslyn Heights' argument that it's not any more intensive, because it's very much so intensive. It's intrusive. And imagine a 330-foot by 13-foot strip right along your property, this far from your house. You wouldn't want that. But if the zoning permitted it, you would have known about it. But if the zoning changes, you're going to feel like that's not fair play. So I hope you will reject your appeal. Thank you.
Thank you. Kristen Miller.
Hi, I'm actually friends with one of the neighbor, and I actually have two dogs, and they're really annoying sometimes. And I've been over to see my friend, and I'm personally annoyed. And I'm coming from a dog owner. There's so many great spaces in Arlington to take your dog to that have been supported by the community already. I don't think it's fair for it to be placed in somebody's backyard without it going through the proper channels. That's it. Thanks.
Thank you. Kelly Walters.
Good evening. My name is Kelly Walters. I'm a unit owner at 1809 North Queens Lane. I purchased my condo in Colonial Village in July 2009, and I'm here to speak on the behalf of the residents of Colonial Village, North Queens Lane, whose units align with the dog run, which behaved as an unregulated dog park when Roslyn Heights erected that fence without a permit. This dog park existed outside of every window of my condo. I could not go to another room to escape or avoid the sounds or the experience of this dog park. It was detrimental to my living experience. The noises were people and dogs running back and forth, people hollering at their pets, people's dogs getting in their own dog fights. They were off leashes. It was operating as an unregulated dog park at all hours, way in the morning, way in the evening. Noise complaints, I don't think, would support the resolve to this issue. I'm so glad that the fence came down, and I'm pleading and begging that you keep that fence down and work with what the zoning administrator has suggested here. I believe that she was justified in determining that the dog run would have a significant negative impact and cannot be administratively approved. I urge the board to reject the appeal by Roslyn Heights and affirm the zoning administrator's notice of violation. This has been such an awful experience to live with, and I really urge and hope we can make a resolve so that life can move forward for the residents and we can keep and find our peace again. Thank you.
Thank you. Jane Friedman.
Situation has been going on for about 18 months now, and to me there's no question that the zoning administrator got it right. In fact, in the report, my condominium is pictured, and I think it's maybe, I don't think it's as far as I am right now from you. And the noise is really intolerable, and I think what has been left out of the discussion so far is how forbearing the neighbors of Colonial Village have been. We all know that residents of Roslyn Heights walk their dogs through our grounds. And I have not complained, and I know most people have not complained. We don't order these people off the property. We don't complain about the car alarms going off in the middle of the night. There are certain concessions that everyone has made, I think, to be good neighbors. And the noise in the middle of the night, and really sometimes all day long on weekends. I'm a teacher and I work at home a lot correcting papers, and I can't with the volume of a dog park. And I think Arlington County has done so many wonderful things with dog parks. I know some of my neighbors, I see them putting their dogs in the car to take their dogs to a dog park to exercise and run and bark. So I would be very, very grateful if the zoning administrator's position could be upheld. Thanks.
Thank you. Last speaker, Jace Bauer.
Hello, my name is Jace Bauer. I am a resident of the Roslyn Heights apartment complex. I'm here tonight to speak in support of allowing the continued use of the dog run at Roslyn Heights. I moved to Arlington last summer with my 1-year-old border collie. He is a sweet, energetic dog who loves to play fetch. I chose Roslyn Heights in part because of the great fenced area where my dog could play. I wanted to just take a moment tonight to let you know how much this dog run has meant to me. Being new to the area, I didn't know a lot of people. Spending time at the dog run allowed me to meet some wonderful individuals and feel a sense of community. And this used to be a wonderful little spot in my neighborhood. I would like to advocate for compromise if we can. I think that we can surely come together and find a solution that would benefit all parties. I know of other apartment complexes in Arlington that have dog runs similar to this, and I'd like to see this little spot preserved. I would also like to speak personally. I'm embarrassed and disappointed that my management company has disrespected the board in this manner by not showing up. And so I'd like to apologize on their behalf. They'll definitely be hearing from me. And with that, I thank you for your time.
Thank you. That's the last speaker. Comments, questions,
Madam Chair?
motions?
Madam Chair, just want to, I think the neighbors have made a great case, but I just want to clarify with the zoning administrator the thinking. This slide that's up right now, in a couple of places, or maybe more, refers to dog run. Is that a defined use?
Not in the zoning district. Not in the zoning ordinance.
So why is this here? Why is the dog run not permitted? If it's not a defined use, how can it not be permitted?
So there is a provision if a use isn't currently listed, that you could make a similar use interpretation. And you look at, I can't remember the section number, but you look at the characteristics, the hours, the size, different types of things about the use to figure out what's the closest to it and then make a determination. So if we look at what we have in the ordinance for animals per se, we have animal hospital, kennel, and I think there's another one. If you want to say, well, it's close, if it's closest to those types of uses, you look at animal uses. There are no animal uses allowed in this zoning district. Then you would say, well, dog parks are similar because they allow dogs to run freely. Those are currently permitted as accessory to public parks. Public parks are permissible in the zoning district via approval of a use permit. So that would be a separate approval process if it was deemed that was acceptable with approval by the county board. The main reason for my determination is that I didn't feel comfortable that I could administratively give a yay or nay given the nature of the use and the zoning district and the site plan approval.
I think your argument about the site plan and the buffer are compelling, and I think that's what the neighbors are addressing. My question, and it's not a question to you, because I don't think you can answer a theoretical, but if the building management wanted to cite this use someplace else on their property, would that be something that would be open to discussion? Or is it because you've said a dog run is not permitted? It means they could never ask for a dog run anyplace else on the site.
If you don't mind, I think I'll field that one for the zoning administrator. It's something that's the question you're asking is just beyond the scope of the zoning administrator's authority. That's a question that could be posed to the county board, and I think it would require a text amendment to the zoning ordinance. So I mean, it's a bigger issue. She has no authority to change the uses on the site, either by the permitted uses in the zoning district or the site plan. These are county board questions. And as you know, from your experience, long time volunteering on boards and commissions, that's a very long process that requires necessarily a lot of community input, because we do live in an urbanized area, and these uses have impacts, especially ones such as this that you've heard the neighbors talk about.
I still have the floor. So one of the speakers referenced, and I don't know personally, that they are aware of other apartment complexes that have dog runs. Are you saying that all those are illegal?
I can't say. I mean, I'd need to know specifically. They're probably not permitted.
I mean, but if you just kind of said you have to have this big discussion about whether this use is permitted.
We'd need to kind of know which property, what the site plan says, what's the zoning district.
The site plan, yeah, obviously the site plan.
A lot of moving parts in these determinations, and so if it's true that there are others out there, they may or may not be permissible. My sense possibly is that they're not permissible, even though they may exist, and I think probably there's a lot of zoning violations out there that exist, but the county doesn't go looking for them.
Right. Okay, thank you.
I'm similar, kind of a follow-up. And I think it was mentioned earlier, and it might have been Ms. Malice who raised this issue earlier. Hypothetically, a multifamily building is constructed by right, absent the site plan process. That's possible, correct? Mm-hmm. Now, on their land, within the setbacks, they build a fence and call that a dog run for their
pet exercise area.
A pet exercise area. What ordinance prohibits that?
With your indulgence, I'm going to respectfully decline to have an intellectual discussion about what might be permitted in certain instances.
By right, absent the site plan, because that's what this is, again, hinging on. Absent a site plan, something constructed by right, it's multifamily, and those families agree, their association, their HOA agrees to build a fenced-in area.
That may be something that's allowable. I think that we're here today, we're trying to deal with what we have in front of us.
May I ask a sort of a procedural question? Are we required, if we were to decide that the zoning administrator is correct as to the interpretation of the landscape plan, but we were not as sure about the interpretation of the zoning ordinance, this by right question that some of my colleagues have gotten, are we required tonight, or if we rule at all, there's also that issue, right? But if we were to rule, let's say those procedural issues were resolved, if we were to rule, are we required to rule on the zoning ordinance interpretation as well? Or could we limit an affirmance to just the grounds where we're sure that affirmance is merited?
Well, Madam Chair, if I might, historically, and we kind of deviated, the only question would be asked is, was the zoning administrator correct, as the code says? And then we would do roll call, and we would go yes or no. That would be our vote. And it wouldn't, I see that they ask us to make findings that historically was never done. We would simply say yes or no to the zoning administrator's determination or decision, or if it was a notice of violation or whatever, we would just say yes or no. So we wouldn't split hairs. We wouldn't say, well, partly right, partly no. 1/3 of her argument is correct, but it would be simply yes or no.
Well, I would be prepared to make a motion to affirm the zoning administrator's ruling, but I would not take the resolution as presented. I would strike the last couple words if I were to make the motion.
And then, Madam Chair, if I might, I would suggest that the motion would be, was the zoning administrator's decision correct? Not their findings, but merely...
But this is the resolution.
Madam,
well, yeah, but that's we're not bound by that resolution.
Madam Chairman, I would seek to be recognized to make a motion.
So, go ahead.
I'm going to move a version of the resolution that affirms the zoning administrator's ruling. I guess I should read it into the tape recorder. Is that right? Is that the procedure? Okay. Whereas the Board of Zoning Appeals, BZA, has held a duly advertised public hearing on April 13, 2016 on case number V111216APP1, an appeal of the acting zoning administrator's determination that the fence constructed by appellant was a violation of the approved landscape plan for site plan number 161-7. The use is permitted pursuant to site plan 1617 and the Arlington County zoning ordinance, and whereas the BZA finds that the acting zoning administrator's determination is valid and correct, now therefore be it resolved that the BZA hereby, and I'll just pause for a moment and note that I'm going to not now read exactly the words that were in our report, that the BZA hereby affirms and upholds the action of the acting zoning administrator in determining that the appellant is in violation of the approved landscape plan for site plan number 161-7 and the uses permitted pursuant to site plan number 161-7, period.
Second.
I apologize, but I kind of, could you repeat the new version?
It's the same as the version in our report, except nothing on the last line, which says, and the Arlington County zoning ordinance. I did not read any of that.
Okay.
And then I had an and before the Oxford comma there.
Okay, so that you changed the comma to and you struck the last part.
Discussion? Is the motion moved and seconded?
I have a comment, because I know we talked about this whole analysis of, similar uses, and part of that discussion was looking at the ordinance, seeing what is permitted here, what's like it, that sort of thing. So the question for me is, how important is the last part that's being struck here? And is that, are we leaving open something? Are we deciding the whole question? That would be my concern. How necessary is that last little bit about the Arlington County zoning ordinance? Because I think it keys into the whole analysis. I understand, we're talking about the site plan, but That's my concern.
Madam Chair?
Yes.
From my point of view, I am prepared to affirm the zoning administrator's ruling entirely on the site plan and not the uses that may underlie it, because I'm not exactly clear on that question. I think for me it would become a prolonged discussion and debate on the uses. So if, as my colleague, Mr. Smith says, it's sufficient just to say yes and not have to give a lot of reasons.
Well,
And I would add, Madam Chair, an appellant, I guess I'm always worried about what the record says, being a lawyer. I just think that before the circuit court, they're de novo. So it doesn't really, that the appellant would re-argue whatever legal points or factual points they wanted to on an appeal before the circuit court. So that's why I take the position that it's merely not really parsing the analysis of staff, but simply determining whether ultimately I agree with them or not, even if my analysis is different. Because at the next step, if there is, it would be a new day for all the parties. I wouldn't want the appeal to be based on representations that were made here in terms of parsing the language of a staff report.
Other comments? Okay, motion moved and seconded. All those in favor?
Aye.
Aye. Opposed? 5-0.
Thank you. I have to take a bath. Yeah, that's it. Break.
While the room's being cleared, I'm going to make this.
Yeah.
You were taking a break real quick.
Yeah, there are two members. I mean, we still have a quorum, but there's no chair or vice chair.
Well, Paul, my view on this was that just based on the landscape plan, that it's kind of like the doctrine of constitutional avoidance. Why would we start to create precedents about the BZA's view on the zoning rights if it's not necessary, and leave that for another day?
Let's go. Can we go, please? Can we start?
And then we would hear better arguments about it.
Yeah,
So that
I
was
guess
my
in a way it was good. The ordinance talks about site plans, so I can see that too. I mean, would you? It seems like that's the case.
Okay.
You know what I mean? What's kind of
Okay, can we call the next case, please?
Absolutely. All right, the rest of our cases tonight will be mostly use permits and a variance that we're actually going to hear, the other two being withdrawn. So our first use permit case tonight is V-11080-15-UP-2. This is a use permit request by Robert and Kristen Groves to permit a setback of 18.8 feet to the eave and 19 feet to the wall of a new one-story addition from the right side property line instead of 25 feet. Or sorry, I said right side property line, 27th Road North right-of-way instead of 25 feet as required. Then we also have 0.2 feet to the eave and 0.7 feet to the wall of an existing rear shed from the rear property line instead of 10 feet as required. It's all for the construction of a new one-story front addition, also to maintain an existing non-conforming rear detached shed in its current location. This is in the R6 zoning district on the premises known as 5100 27th Road North.
Questions for staff? We hear from the applicant, please. Sorry, would you identify yourself, please?
Robert Gross.
And do you have anything to add to the staff report?
We have an expanding family, and I have a home office. I'm very busy, actually. I'm an accountant, so I'm in tax season right now. And most of the basement is used for my office. I have an assistant and clients coming over a lot, so majority of the basement is used for my office, and we just need a little bit more space for my children, and that's really it.
Okay, thank you. Any questions of the applicant? Motion?
Is this the one with the rear shed that's on the lot, on the rear lot line?
Yes. Yeah.
Okay, and we had the explicit support of the neighbor abutting on that side, right?
He actually helped me build it.
Okay. And they have a shed on their side too, right?
It's a two-car garage.
Thank you.
You were also passed out a plat tonight. There was an additional plat showing that eave line that wasn't originally in the packet, so we have a copy there in front of you. It's the 8.5 by 14 plat copy you have.
Comments, questions? Motion?
Madam Chair?
Mr. Smith.
I move that the Board of, that in the case of V-11080-15-UP2, that the Board of Zoning Appeals adopt the attached resolution granting the use permit.
Second.
With the conditions described in the staff report.
Second.
It's been moved by Mr. Smith, seconded by Ms. Malice. All those in favor?
Aye.
Aye. Thank you.
Thank you.
The next two cases are both going to be deferrals. This is case number V-11093-15-VA-1. This is a variance request by Carl Bernstein and Jeffrey Cuck to permit a main building footprint coverage of 29.4% instead of 28% as permitted. Also a total lot coverage of 40.7% instead of 38% as permitted. It's for the construction of a new 2 1/2 story home. It's in the R8 zoning district on a premises located between 2256 and 2264 North Upton Street.
Recommend for deferral. I assume the applicant doesn't need to say anything. Thank you, Mr. Lawson. That was the right answer.
Madam Chair, I just point out this was what we heard last month, and sort of suggested that a 1-month deferral is tough.
I think more than once. More than once, actually. Go right ahead.
I'd like to move that the BZA defer variance request number V11093-15-VA-1 to the May 11th BZA hearing.
Madam Chair, I'll second that, but I want to know if there are any speakers here on this.
I don't have any speakers on this item. Thank you. It's moved by Ms. Malice, seconded by Mr. Smith to defer. All those in favor?
Aye.
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 Next case is the associated use permit. Is V-11093-15-UP-1. This is a use permit request by Carl Bernstein, Jeffrey Cuck to permit a setback of 6.4 feet to the eave and 7.4 feet to the wall of the home, 6.9 feet to the porch eave and 7.4 feet to the porch base, and 7.5 feet to the rear deck and 5.1 feet to the chimney from the right side property line instead of 13 feet is required, and then also an aggregate side yard of 13.7 feet instead of 21 feet is required. It's for the construction of a new 2.5-story home with a front porch, a right side chimney, and a rear deck. It's in the R8 zoning district on the premises located between 2256 and 2264 North Upton Street.
Motion?
I'll make a motion.
Thank you.
All right. So in reference to case V1109315 UP1, I make a motion to defer this application to the May 11th, 2016 BZA hearing.
Thank you. Second?
Second.
Moved by Mr. Melnick, seconded by Mr. Smith. All those in favor?
Aye.
Thank you.
This is case number V-11119-16-UP-1. This is a use permit request by Marcella Rabetti to permit a setback of 6.9 feet to the left side bay from the left side property line instead of 10 feet is required. So 15.2 feet to the eave of the second-story addition and the new two-story rear addition, and then 16.2 feet to the wall of the new two-story rear addition from the rear property line instead of 25 feet is required. Then finally, an aggregate side yard of 10.8 feet instead of 18 feet is required. It's for the construction of a new left side first floor bay and a new two-story rear addition, and then an eave overhang for a new second-story addition above the first floor walls. It's in the R6 zoning district, premises known as 920 26th Place South.
Thank you. Questions for staff? From the applicant, I have Francis Durkin. Are you representing the applicant? Can she speak for herself? Certainly. Sorry.
Good evening, members of the board. I love living in Arlington. I love my neighborhood and I love my house. I have lived in my house for 11 years now, and my neighbors have truly become my extended family. We celebrate holidays together, rely on each other for support during tough times, and rejoice of each other's accomplishments. I live in a lovely house. It's perched on a hill, and it has a lovely character, an amazing character, and it has good bones too. So much of my life has happened in that house. I do not want to leave, but I do need to reconfigure certain rooms and had just a little bit more space to be able to live comfortably in it. For this reason, I kindly request that the board grant me permission to construct 2 small additions as depicted in my proposal. For the most part, my neighbors support my request. I thank you for your consideration.
Thank you. Francis Durkin is not going to speak, or are you? Okay.
Good evening. I'm Francis Durkin. I'm the designer of the additions, and I just want to point out that we're asking for rather modest relief on 2 sides for a total of just north of 100 square feet, which, as you know, in Arlington is rather a small request. I would like to point out that because of the topography, because of the character, we can't really go out the front of the house, but also because of the topography. But in the back, the addition will actually have less impact than a similar addition on another site because the house sits so far below the alley that's held by the retaining wall. And that's it. Thank you.
Thank you. Joseph Small, please.
Good evening. My wife and I live directly behind Miss Rabetti. Between our houses is an intervening utility alley that's owned by the county. We have issues with this use application. I have put in the record some pictures and a written statement. I would point out that there are 3 issues in my mind that I would ask the board to consider. They are, first, the accessibility of the property in the rear, the density of the building in the rear, and therefore the resulting public safety. It's important to keep in mind that this house in the rear is surrounded by a 1-foot thick reinforced concrete wall, which has a depth at some points of up to 6 feet. It's virtually inaccessible from the rear alley, which in itself has issues because of the topography and that the clearances are low. Furthermore, the density that we're talking about here is greater than a small change. The density takes a current encroachment, which is unpermitted, of 96 square feet and increases it to, I think, 256 square feet. In terms of volume, we're going from basically 800 square feet, 800 cubic feet, to a volume of over 2,000 feet, 2,000 cubic feet. The result of this is increasing density in the rear, which makes it virtually inaccessible to emergency vehicles if there were to be a problem. And accessibility from the front is almost impossible because there's no accessibility from the left side. On the right side, the accessibility is at most, after you take into account things such as chimney outcroppings and air conditioning, probably a little over 3 feet. And then there's a sheer drop from the right side to the neighbor's lot of about, I would say, 8 to 10 feet. We are very, very friendly and fond of Miss Rabetti. We wish her all the best in the world, but we think that the result of this use permit would be to basically endanger the public safety. And it's not consistent with the surrounding property, which even the staff report admits. Thank you very much.
Thank you. That's the last speaker. Questions, comments, motion?
Madam Chairman?
Yes, sir.
The last speaker asserted that there is, I think he refers to his letter as an apparently unpermitted addition. Does the staff have any comment on whether or not there is any unpermitted addition that exists now?
We were not able to unidentify any part of that that's unpermitted. As far as our plat books go back towards the 1950s, we see that structure there. This house was built in 1940. At some point that was probably either original or added on, but we don't have anything saying that it was unpermitted.
So it sounds like your best guess is that it's existing non-conforming.
Most likely, just like the rest of the house.
Okay.
Any other questions? No, sir. Thank you.
I do have a question for the applicant.
Yes.
Sir, sorry to ping pong you, but I do have a question for you.
He's not the applicant.
I'm sorry, not the applicant. I'm sorry. Do you see any way to improve the situation short of simply denying it?
That's a very good question. I have thought about that. I think currently the situation that we've got is still is a threat to public safety. I cannot offer an alternative. I would like to point out that the current encroachment in the rear was not part of the original construction, and that is in the record, and there is no record that it was ever permitted. But to answer your question, I've thought hard about that, and I cannot think of an alternative. Thank you.
Thank you. Any other comments? I hear a motion.
Madam Chairman, I'm going to move the adoption of the resolution approving the use permit in V-11119-16-UP1 with the conditions that are described in the staff report, because this is a tough lot, and the topography really does limit what can be done, and the proposal is rather modest, and you really can't do anything on the front because of that topography. And that's why I would move the adoption of the staff's recommended approval. Well, the motion is to, I move that the Board of BZA adopt the attached resolution approving use permit V-11119-16-UP1, subject to the conditions that are listed in the staff report.
Thank you. Second?
Second.
Thank you. Moved by Mr. Smith, seconded by Mr. Melnick. All those in favor?
Aye.
Aye. Thank you. It's approved.
Didn't ask for opposed.
Opposed?
No.
Thank you.
Okay, the next case is a deferral. It's V-10888-14-UP-5. This is a use permit request by Elaine Capusta to permit a setback of 10 feet to the eve of a new third floor addition from the 21st Road North right-of-way instead of 25 feet as required, and to permit a building in excess of 2.5 stories within 25 feet of a street right-of-way. This is for the construction of a new third-story addition above the existing second-story walls. It's in the R5 zoning district on a premises known as 4133 21st Road North.
Thank you. Motion?
I'm happy to move this, but again, point out this was a one-month deferral. And I really think that we waste time on everybody's part making these one-month deferrals when it's,
Well, then make
it's
it,
just, it's too
then
quick.
change it.
So that's just advice for ourselves. I move that the Board of Zoning Appeals defer use permit V-10888-14-UP-5 to the May 11th BZA hearing.
Second.
Moved by Ms. Malice, seconded by Mr. Smith. All those in favor?
Aye.
Aye.
Opposed? It's carried. Thank you.
Okay, next case is V-11123-16-UP-1. This is a use permit request by Stephen Fuss and Jennifer Gardner to permit a setback of 17.5 feet to the eve, 18 feet to the porch base from the South Culpeper Street right-of-way instead of 21 feet as required. It's for the construction of a new front porch. This is in the R6 zoning district on a premises known as 2431 South Culpeper Street.
Questions of staff? We'll hear from the applicant, please.
Yes, hello. My name is Stephen Fuss. I'm my wife and I are the owners of the house. Just want to say we've been in the neighborhood almost 17 years. We love the neighborhood, and we've always wanted to have a porch on the front. What we're looking to do is very similar to what's been done by, I think the report shows 5 other properties in the neighborhood, and we're just asking for a couple of feet to encroach on our setback.
Thank you. Questions of the applicant? I don't have any speakers.
I'll make a motion. You can make a motion.
I'll second the motion.
Okay. So, let's see. In case number V-11123-16UP1, I would move that the attached resolution granting the use permit be adopted with the condition as listed.
Second.
Moved by Mr. Melnick, seconded by Mr. Smith.
Moved by who? Oh,
Paul.
Melnick, okay.
All those in favor?
Aye.
Aye.
Opposed? Carried. Thank you.
The next case is actually going to be a withdrawal. This is V-11124-16-VA-1. This is a variance request by Christy and Jason Blackham to permit the construction of a new detached one-family home on a lot that does not meet the required lot width. This is in the R27 zoning district on a premises known as 2109 South Shirlington Road.
Motion?
I move that the Board of Zoning Appeals withdraw the variance V-11124-16-VA-1.
Second.
Moved by Ms. Malice, seconded by Mr. Melnick. All those in favor?
Aye.
Opposed? Thank you.
Okay, the next case is V-11125-16-UP-1. This is a use permit request by Catherine Biersack to permit a setback of 4.1 feet from the left side property line instead of 9.8 feet as required. Also, an aggregate side yard of 15.3 feet instead of 21 feet is required. It's for the construction of a new left side carport. It's in the R8 zoning district on a premises known as 2548 North Upland Street.
Questions of staff? Hear from the applicant, please.
Hi, good evening. Thank you for allowing me to be here today. This house has been in our family since 1964. In your packets, there's a little picture of me. I'm the little dot. I'm not riding the tricycle. And all I want to do is replace the carport that my father had taken down at some point, I believe in the late 80s or early 90s, when I was stationed abroad in Turkey and Germany. I don't really know. I left and I came back and there was no carport. But he took it down because there was some disrepair to it, and it was a rental property at the time. We lived in that house on and off from 64 to 72. My dad was military, and then it was a rental for 35 years until I moved in. And I've been restoring this house meticulously, as not the same utilities, but back to 1952. I'm just trying to keep it the same little Roy Hill Rambler. And I just want a carport, especially after this winter, just to keep the elements off the car. I've talked to all my neighbors, and signatures. I thought beyond that would have been obnoxious. And my neighbors across the street on both sides they don't have a problem with it. It will be a flat roof, just as in the previous pictures. And then my neighbor, looking at the carport to the left, she's just recently done a bunch of work by permitted a pond and stuff, and everything's native plants. So we're going to be doing a rain garden just to the left side. But we don't really think there's going to be any more water shed than there currently is. I just really want it just to get my car out of the elements.
I have a question. Okay, so I noticed in the staff report, and just as a background, of course, what we always try to do is see if there's any options to actually, to comply, even though we're talking inches here.
Right.
But the staff said that if it's moved back a little bit, then it will comply. Have you considered that?
Well, I looked at that, and that would require the removal of the Leland cypress tree, and I would really not want it. My neighbor probably wouldn't want that done either because it's a nice block between the two homes.
Mm-hmm.
If we go back any farther, we're going to disrupt the root system and have to remove that entire tree.
Okay. Thank you.
So I did. I looked.
Okay.
Any other questions? Motion?
Well, Madam Chair,
Yes, sir.
I want to move the alternative resolution. That's what was advertised. And therefore, I move that the Board of Zoning Appeals adopt the attached alternative resolution approving use permit V-11125-16-UP1, subject to the conditions listed in the resolution.
Second.
Moved by Mr. Smith, seconded by Mr. Owen. All those in favor?
Aye.
Aye. Opposed? Thank you.
The next case, we're actually going to do a withdrawal motion on this one. I'm sure you all got the email recently about this. This is V-11126-16-UP-1. This is a use permit request by Andrew Souls and Samantha Bird to permit a setback of 0 feet to the right side property line, the left side property line, the rear property line, and the Lee Highway right-of-way instead of 100 feet as required. It's for a detached chicken coop as well as a yard area for raising chickens. It's in the R6 zoning district on the premises known as 6611 Lee Highway.
I was so looking forward to this discussion. Can we have a motion, please, for withdrawal?
I'm in the case V-11126-16-UP-1. I move that the Board of Zoning Appeals withdraw the request for a variance.
Second.
Oh, sorry, it's use permit. It had a V number. Sorry? Oh, but a UP at the end. So the use permit.
Moved by Ms. Malice, seconded by Mr. Melnick. All those in favor? Aye.
Aye.
Opposed? Thank you.
The next case is V-11127-16-UP-1. This is a use permit request by Jean-Pierre Bluen and Patricia Healy to permit a setback of 15 feet to the eave and 16 feet to the porch base from the South Quinn Street right-of-way instead of 21 feet as required. And also 3.7 feet to the eave and 4.7 feet to the porch base from the left side property line instead of 8 feet as required. This is all for the reconstruction of an existing front porch and also a partial porch enclosure. It's in the R5 zoning district on a premises known as 1027 South Quinn Street.
Questions for staff? We hear from the applicants, please.
Hi, I'm Patricia Healy. So we're going from chickens to 1904 farmhouse. We were asking, my husband and I, that the board permit the use to replace the existing front porch, keeping the existing roof line. Our house, the reason we're asking is, there's a lot of maintenance with a house that's 112 years old, and with the boards constantly trying to replace them, we just need to start afresh. New footers, that type of thing, keeping the existing roof line. So we had to keep the same footprint of the house and keeping the same lot coverage. The proposed porch is in keeping with the original structure, the 1904 structure, and I believe it will improve the aesthetics of the neighborhood. Many of our neighbors have enclosed their porches or redone their porches, and they have similar setbacks. We have the support of our neighbors. We recently had some new neighbors move in, and I have just kind of refreshed everybody, re-signed letters, and I have copies of their support here.
So
one packet each.
One packet each. Sorry. Thank you. Thank you.
Sure. Okay, is that the same thing?
Okay.
Thank you.
We're good.
We're good. Thank you.
Thank you.
Any questions?
Madam Chair, question for staff. Did you notice the unusual addresses?
Yes.
On this plat?
Yes.
27 end up being between 25 and 24.
Yeah, how do you get an even number on the same side of the street?
I couldn't tell you. This is a very different neighborhood. I mean, I think you all probably remember the two homes behind it that you heard a year ago, I think. So this neighborhood just has an interesting dynamic in general, just how it was developed in the first place, and then all the infill that's gone into it. So it doesn't surprise me.
It's just curious.
Okay. Motion?
It's a historic black neighborhood. Charles Drew lived there. Dr. Drew lived there.
Okay, let's go.
Madam Chair?
Yes, Mr. Smith, being a porch dude.
Give it, yes, absolutely. I grew up where all the porches were lined up and we had to play on the porch at night. So I'm always a fan of porches. Therefore, in the case of V-11127-16-UP1, I move that the Board of Zoning Appeals adopt the attached resolution granting the subject use permit with the conditions listed in the staff report.
Second.
Moved by Mr. Smith, seconded by Ms. Malice. All those in favor?
Aye.
Aye.
Opposed? Thank you.
The next case is V-1128-16-UP-1. This is a use permit request by Rita Thompson and Michael Howe to permit a setback of 20.5 feet to the covered stoop from the 18th Road right-of-way instead of 21 feet as required. It's reconstruction of a new covered front stoop. This is in the R6 zoning district on a premises known as 5629 18th Road North.
Questions of staff? We hear from the applicant, please.
Good evening, I'm Rita Thompson, and I'm here to request that you approve this request. It's a curb appeal project, actually. We're talking about 6 inches. The entire house was built wrong, and we only want to replace the front stoop and make it more attractive. This wouldn't wait 5 minutes in HGTV. I have the support of 5 of my homeowner neighbors, and just request your support.
It's probably the rules that changed, not that it was built wrong. That's my guess is.
Survey technology has changed. That's probably more likely.
Madam Chairman,
Mr. Owen.
I'm prepared to make a motion, if that's okay.
Thank you.
I move that the Board of Zoning Appeals adopt the attached resolution granting the use permit subject to the conditions listed below.
Second.
Go ahead.
Moved by Mr. Owen, seconded by Ms. Malice. All those in favor? Aye.
Aye.
Opposed? Thank you.
Okay. Next case is V-11078-15-UP-2. This is a use permit amendment request by Alex and Roberta Maselli, and this is to permit a setback of 9.4 feet to the wall from the rear property line instead of 25 feet as required, and 18.8 feet to the eve from the North Upton Street right-of-way instead of 25 feet as required. It's for the construction of a new eave for a second-story dormer above the first floor walls and also a new basement level rear addition. This is in the R8 zoning district on a premises known as 2271 North Upton Street.
Questions of staff? We hear from the applicant, please. Welcome back.
Thank you. I was looking forward to the chicken coop thing.
Me too.
I think the zoning administrator has recommended approval, so I don't really think I need to see any more than that. I support that.
Thank you.
Madam Chairman, I have one question on the applicant.
Yes.
Do you know the history of the zoning that resulted in your neighbors to the rear having such odd rear lot lines?
No.
Have you seen this tax map?
Not only well aware of it, I tried to buy some of the land so that we could not have to go through this.
You could have a yard.
Is it follow the topography?
Well, the topography goes, our building.
Well, that's a swale, right?
This sliver, and then.
Yeah, it falls off into a creek, a swale, probably a submerged river or creek that's probably been paved over.
Yes.
But they own that. I mean, 2,300 to the rear on Trenton, they have, he has, 250 feet of...
And he pays taxes on it every year.
He could fit a chicken coop.
He what?
He could fit a chicken coop.
He could have, yes, several of them, right? They're 100 feet from the road.
Goats.
Or goats.
Okay, it's getting a little crazy here.
You started it.
I started it, I have to apologize. Madam Chair?
Yes, sir.
In the case of V-11078-15-UP2, I move that the Board of Zoning Appeals adopt the attached resolution granting the subject use permit with the conditions that are listed in the staff report.
Second.
Moved by Mr. Smith, second by Mr. Owen. All those in favor?
Aye.
Aye. Opposed? Thank you.
Thank you. Hope not to see you again.
Bye.
You may.
Okay, the last two cases are associated. This is the variance. This is V-11129-16-VA-1. This is a variance request by Teresa Bosch for an addition exceeding 50% of the aggregate floor area of the existing building on a lot that does not meet the area requirement of the R27 zoning district. It's in the R27 zoning district on the premises known as 848 South Irving Street.
Questions of staff? We hear from the applicant, please.
Hi,
My name is Teresa Bosch. I am the president of Bosch Homes LLC, which is a small Class A contracting company. My father will speak in a moment, and I purchase one home at a time and renovate it. This one came to our attention. I'm not sure if we bought from the original owner, but it's almost unhabitable as far as we're concerned. There's not working. The plumbing is an active leak, like we have to keep the water shut off. And it looks like a good candidate for our work. I think it has solid structure, good bones. It's in a beautiful neighborhood. We believe that it will be more appealing to buyers, more attractive to buyers, with an addition that's consistent with some of the other additions in the neighborhood. We've purchased an Arlington County business license, and we do want to be compliant with everything. The proposed addition meets all setback requirements, and it does not exceed lot coverage. So we're applying for, and I get confused which is which. The use permit is for the side lot setback?
Correct.
Okay, so we're just applying for a use permit permitting the setback of the existing house that's non-compliant. The addition will be compliant. And the variance is for the size of the addition, and we feel that it's consistent with other homes in the neighborhood, that it makes it an appealing property. We have a signed agreement with the adjoining duplex owner, addressing any concerns she has, stating improvements we'll make to hers as well, so that the overall curb appeal can be improved. And I did want to point out that we have one of the longer lots in the neighborhood, and that we will still have 36 and a half feet from the rear of the proposed addition to the rear of the property line.
Thank you. Questions of the speaker? I have Norma Ebris, speaker. This is on the variance.
Good evening, Chairman of the Board. My name is Norma Abris, and I live at 850 South Irving Street, next to the 848. We've been living in that house for 18 years, and we love it. And we purchased that 1998, and we have done the addition at 2001 extension in the back. So we did apply the variance as well back then to have the to move our wall to the property line, which is what that was Miss Teresa doing now, and we disagree with that because we're living from the property line 3 feet away, and when we applied, we didn't granted our request. And we've been said that for reason is that by law, the zoning is 10 feet away from the property line. So that's why I'm disagreeing.
Questions of the speaker?
I'm sorry.
So
can I say more?
So you had applied for a variance?
That was 2001, yes.
And were denied?
Yes, ma'am.
Your addition was on this side, the side that they're
We're
building on?
supposed to in the side, yes. The 848. And we didn't get that. We got granted in the back the extension, but we didn't even leave, the original wall in our house.
Okay.
Because they said we can't move out like that.
Thank you.
Okay. Thank you.
Thank you.
Madam Chair?
Yeah, just a second. Carl Santillo?
Hi, my name is Carl Santillo, also a member owner of Bosch Homes LLC, in business with my daughter. We see this as an attractive project. The house is in disrepair. What we're looking for is an economically feasible way to make a significant investment in the property for the improvement of the house and the neighborhood. There's two reasons why a smaller addition wouldn't work, particularly. One is the specific layout of the floor plan, and the narrowness of the house means about the only way to get from the old house to the addition is to destroy a bathroom. So that's okay. the bathroom becomes a hallway. Now the first thing you have to do in the addition is replace the bathroom. So if you have a very small addition and you've replaced the bathroom that you had to destroy to get to the addition, it doesn't make for an economically feasible approach. The other thing, from a construction standpoint, costs don't go per square foot. You still have to go through all the trades, and it's much more effective per square foot to make a larger addition. It fits well on the property. As Teresa said, it's still 36 feet from the back. And I want to make it perfectly clear, with regard to 850 South Irving, the addition is still 10 feet off the line as required setback. There's no encroachment. We're not asking for any exception on their side of the property. The existing house does not meet that. I believe it's 7.9 feet. That's been there for years. The addition would be more narrow than the existing house, so it is a full 10 feet away from the property line as required. So we're not encroaching on anything toward 850 at all. We are asking for the variance to have in excess of 50 square feet addition. So the resulting house is a modest adjustment to allow us to build as requested. We meet the required side lot clearance, the backyard clearance, no chicken coops, and we urge your consideration of the alternative recommendation for both the use permit and the variance application.
Madam Chair, a question of the applicant. Either you could go ahead.
Okay. So, as you know, the analysis for a variance is, definitely different than a use permit. And we're not just looking at setbacks. But what the staff has brought up here is that you purchased this on November 3rd, 2015, with the intent to expand. And so, in your due diligence, you must have known about the zoning rules and what it is and what the ordinance says how big things can be. Yet you bought it anyway. And so that's what they're saying about. Yes.
So we bought it on November 3rd. I don't know the exact date in November, but later in November we came and sat down with a staff member in zoning, and I couldn't tell you his name, but I could tell you where his desk is, and said, before we spend it, we could renovate this as is, we can build onto it, like what should we do? Before we spend any money drawing up plans, talk to us about setbacks, what's required. We want to make a conforming plan. And he told us at that time very clearly that the existing house setback would be grandfathered because it was existing. And then after paying for plans, drawing it up, submitting for building plans, these zoning issues were brought up. But he pulled it up, saw if it was a site plan. Like, we sat down with him and said, what else are we not thinking of before we invest in plans for this project? So I understand there. Then when I brought back the application for the variance, he said, no, it's grandfathered, and there was all this discussion, and I think it was just an honest mistake on his part. But now we're many months in carrying this project. We've paid for plans, and I think it was just wrong information. I talked to Amanda Clement about it when I came in because she had reviewed the plan, and she said, I'll bring it up at the staff meeting. I'm so sorry that happened. You were given wrong information. So we're kind of trying to go forward from where we are today. With the information we were given back in November.
Madam Chair? I don't know that information can enter into our decision because what staff has told you is not part of our record here.
Understood, and he's not here to. But even when I brought in the application, there was some question about whether I needed to make the application on that day, because it was the understanding of the staff member I was speaking to that it wouldn't be necessary because that was pre-existing.
And so the question is, as my colleague was getting to, is a higher standard in terms of that there is a hardship here, that your property is basically unusable without this variance.
I see.
And I'm not seeing that. I'm seeing that
This is our first project in Arlington, and I just felt like it's consistent with it. Like, why would it not be okay? It's consistent with the neighborhood. As a real estate agent, I want it to be consistent with the neighborhood. Like, I don't want an outlier. I want to be consistent with what's developing in the neighborhood and producing something that's desirable on that street because that's what's expected in that neighborhood.
The consistency with the neighborhood is a relevant consideration for a use permit. but I don't think it's a relevant consideration for a variance. And so that's what we're facing, is that in applying Virginia law, we have to apply these different legal standards.
So if I were living in it and said we're having kids and we're growing and we need this space, but it's not okay to build it to attract that kind of
No, the issue is more that variances go to something that's an unusual site. So in fact, a variance is meant for instance, something like the last one we had, although that was a use permit, I guess. But if you're on a hill and no one else has a hill, and so you can't build on the parcel, and then maybe some adjustment needs to be made because your parcel is different. That's an example of something that might be contemplated under a variance. But the scale of economic benefit is not, generally speaking, an acceptable argument, short of near complete inability to get any economic benefit. And this is just a Virginia law standard that we must abide by in rendering our decision.
We say then we can't afford to add and we just leave it an 850 square foot duplex.
Madam Chair?
Yes.
No, staff gave you an option for
Build
expanding
it half the size, or 14 by 15.
Yeah,
and
you know,
we studied that.
Slices are better than no slices of a loaf of bread.
Yeah, I mean, if you're kind of moving a bathroom, yeah, I mean,
You're not stuck to 800 square feet, but you're not. But staff says no to 16. There's a.
But if we feel like it's not feasible to go through the addition process, the timeline that, but if we feel like the half-size addition isn't feasible,
That's your decision.
that's our decision.
Any other comments?
Madam Chair, and I'll say that we get this a lot.
Okay. We're new to it. We're totally new here. We're learning as we go.
South Arlington is full of these duplexes.
Right.
And and they all have, almost every application bumps up against the 50% rule.
Right.
So people come in with more modest variance requests that sometimes staff says that's okay. We don't have a problem with that. We can and they gave you an option, so you're not. It's not a 0 or 100. There are numbers in between.
If we can make that option work for us.
And that's kind of what Mr. Melnick was going to. That in a business decision, you have to measure your risk beforehand.
Absolutely. No, we know that. We knew it was a risk. Can I ask? Is it wrong to feel that there's a different standard as an investor?
It has nothing to do with the ownership.
You're an owner, period. It doesn't matter whether you're an owner, investor, or
So if my hardship is different from, if I moved my family of 4 kids there.
Mr. Olin really described part of it. The hardship has to run with the land more than anything else.
I see hardship compared to other neighbors.
Such as the...
he pointed out that you really can't say we are like other neighbors. That really undermines your case entirely. You have to say we're unique. We have a unique problem. That, and in fact, the code says that it kind of has to be unique, such that others don't share the same hardship.
If you look at the neighborhood and just the little outlines on the map that's included as part of our, and obviously there are additions that cover much more of the lot than what we're proposing. If
one that's almost on Highland that
30,
is really
830 Highland
looks like a.
Well, there's several of them, but if I had those approval letters, like if I appealed and brought those approval letters, would that carry any weight?
And then there's a thing, we don't follow what's called precedent.
Okay.
They're not precedent setting. Each case is viewed on its own.
Okay, so they made a different case.
Yep.
And Madam Chairman, and if I could, my colleague was saying, even if there was an error, that doesn't mean we need to perpetuate it.
Sure.
And that's what you're saying. Just if it's unfortunate if you were told one thing and then had plans drawn up, but it doesn't mean that then we need to perpetuate that and not follow the law.
Right.
So we understand what you're saying.
Okay. Thank you for your time.
Okay.
Motion?
Madam Chair, I move that the Board of Zoning Appeals adopt the attached resolution denying variance V-1129-16-VA-1.
I'll second.
Moved by Ms. Malice, seconded by Mr. Melnick. All those in favor?
Aye.
Opposed? Carries.
The next case and final case for tonight is the associated use permit. It's V-11129-16-UP-1. This is a use permit request by Teresa Bosch to permit a setback of 7.9 feet to the left side property lines to 10 feet as required. This is to bring the existing non-conforming semi-detached two-family dwelling into compliance with the left side yard setback for the construction of a new two-story rear addition. It's in the R27 zoning district on a premises known as 848 South Irving Street.
Questions? Speaker, would you? Okay. Okay, thank you.
I believe this use permit relies on the variance being approved, so therefore I will move that the Board of Zoning Appeals adopt the attached resolution granting a use permit V-11129-16-UP1 for an addition with a gross floor area of no more than 421.7 square feet, subject to the conditions listed below.
I'll second that. That's giving you 4 slices versus a whole loaf.
It's moved by Ms. Malice, seconded by Mr. Smith. All those in favor? Aye.
Are you moving the approval that's in our packet? Is that the motion?
That's what I said.
Okay. All right. I'm sorry.
I think I contradicted myself, but yes.
Okay. So we have before us the same motion that staff has proposed.
Yes, and my understanding, the question I guess now I've confused myself, is can we do this without the variance?
Yes, you can, because all we're doing is bringing the existing building into compliance with the left side yard setback. Therefore, they can come in and do a by right addition to the back, as long as they meet that 50% aggregate floor area rule.
Good? Are we good?
There's a question.
Oh, on this question?
What's the question?
She wants to speak on this item.
The neighbor.
No, I didn't have a
You
speaker
didn't
slip.
put in a speaker slip.
Well, she did for the variance.
I would be inclined to allow her to speak.
Okay.
Yes, we do. Is the second?
Thank you, Chairman, for allowing me to speak again. My understanding here is okay to do the addition in the back, the way I can see it. But to move, farther from the property line I don't approve that from the existing walls.
Staff? Hold it. No. What is it? Would you clarify?
What we're doing is approving a setback to the existing building that's there now so that they can add on an addition that meets all setbacks on the rear. So they can build a smaller addition that is less than 50% of the existing building and still meet setbacks onto the rear without needed variance.
That might
Closer to your house.
Exactly. It'll have to be pushed in to be about 2.1 more feet further from the property line.
Mm-hmm. I'm a little bit confused, forgive me.
Now, you share the party wall on the right side, correct? Or are you on the left?
No,
You're on-
only,
okay.
facing to the house that they bought. I'm on the left side.
Okay,
We have
the addition would have to be 2.1 feet further away from your property line than the house exists today. So any addition would have to be pushed further in and have to be much smaller than they originally proposed.
Mr. Noxon, are you saying that the existing distance is 7.9
Correct.
feet today?
Exactly.
That's the distance between your house?
No, I'm talking,
But,
it's
Madam
hard
Chair,
for me to
you're-
explain.
What we may agree to is not going to move anything closer than it already exists. In fact, if they do anything on the back, it has to be further away from your house. But their house already exists. That's that concrete wall, that brick wall, that's not getting any closer.
It's legalizing it.
Yes, it's legalizing it. Anything they put on the back is going to be further away even
It'll
from
be
your house
10
than
feet.
their current structure.
Oh, okay. So you're saying from the original wall, it's not going to go out like that?
No.
Oh, okay. Okay.
The addition will be even further set back.
Away from you.
Oh, it'll be 2.1 feet further from your property line.
Do you mind if I approach you, ma'am, either one of you, so?
Do what?
Just to make.
Approach the chair.
She wants to see on the drawing.
This one here, this is the original.
Yeah, that original wall. It's not going to change. No.
The addition.
Yeah. Is going to be on the back, and it's going to be further away even. But no, this wall is not getting any closer than it is right now. No change on that wall.
Oh, okay, thank you. That's all I need.
Okay. Okay. Good. We're good. We did have a motion, did we not?
Yes.
Was it duly seconded?
Second.
You made the
I
motion.
seconded the motion that Ms. Malice made, which was to, on the use permit, which was to bring the house into conformity and allow up to 400 roughly 420 square feet on the, and allow up to 50% lot coverage.
50% aggregate floor area.
Floor area.
I mean, floor.
Okay. Good. So we had a motion by Ms. Malice, seconded by Mr. Smith. All those in favor?
Aye.
Opposed? Thank you.
One other piece, now we have a piece of business, Madam Chair, that's not on the agenda, and that is the reorganization of the Board of Zoning Appeals. I would like to nominate you, Madam Chair, for chair of the next year.
Second.
I move Judy Freshman be chair of the Board of Zoning Appeals for the 2016-2017 BZA year.
Wait a minute. 217?
Till April of next year. They're one-year terms.
I have to announce in advance, I won't be here October, whoever's going to cover for me.
The vice chair.
Thank you.
Do you want to do March, just because that's when the terms generally end or begin?
Yes.
Okay.
And I did March, right? I already did March. Thank you.
So you get 13 on this one, and you'll get 12 on the next.
So we would reorganize next March. Is that right?
Yeah.
Okay.
And so, and what about vice chair?
Well, we have to vote on your,
step up.
there
Go
has to be
ahead.
a second,
No, actually, nominations do not require a second.
so we have to vote on it.
Okay.
Yeah, you're going to call the vote?
I'll call the vote. All those in favor?
Aye.
All those opposed? Okay. Next?
Madam Chair,
Vice chair?
I nominate Enta Malice.
Yay. Are you here in October?
Oh, you can decline.
Oh.
I'll nominate Paul Melnick then.
You can fight it out.
And you all can fight
You
it
have
out.
30 seconds to fight it out.
I forgot what we agreed to last
Yes,
month.
we-
Was it Paul?
Yes.
I withdraw. I nominate Paul Melnick, Vice Chair of the Board of Zoning Appeals. I forgot Paul.
I'll second that. Okay, all those in favor?
Aye.
Aye.
Good, we're done.
Madam Chair, I
Yes.
nominate Drew Noxon as Secretary of the Board of Zoning Appeals.
Oh, we got to do that too? Okay, I second that. All those in favor?
Aye.
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 Anybody else?
Madam Chair, having reviewed the minutes from our March meeting of the Board of Zoning Appeals, I move the adoption of the minutes, which are in front of us.
Second. Second? Minutes approved by Mr. Smith, seconded by Ms. Malice. All those in favor? Aye.
Aye.
Abstain.
Abstain. Anything else?
Thank you for the water.
Yes.
Oh, you-
I guess I move to adjourn.
We're no longer doing the water bottles per the county board's request.
Very refreshing.
As you all know. And actually staying here till after midnight is county policy too. We're not supposed to do that anymore, but
Oh, well, I
luckily
hope,
we haven't had to
I
do
mean,
it.
this,
Stay past midnight?
this meeting started out like a train wreck, so I'm grateful
don't
that
know
we're
who's gonna
getting
force
out
us
at
to,
a
but-
decent hour.
Yes, congratulations.
And welcome, Mr. Owen. I think you did a wonderful job. You made a motion tonight. You were an outlier. You voted against some motions. It was a wonderful meeting.
No.